Mention the application. Yes. Paragraph 2. Because other heirs have transferred the property because of agreed. Paragraph 2. Nalishi proof of appellant number 3. 1 and 2 is the appellant. Defendant number 1 and 2 is the appellant. Nalishi बादी को now what pointed that will take the paragraph 6 contention in the Binyankan application. Nalishi proof के बाद में that discount possible father and son. Permission Zoya, admitted case. I am not obtained permission. Now it is not construction a valuable system অংশাপেক্ষা বেশি অংশ থাকলো চুরি করিয়া paragraph sorry not page 80 similar not government paragraph 1 is paragraph there is now page 21 my start only one paragraph page 27 paragraph 5 that is question number 4 and 5 would read as the mud house mud built house and also question number 1 and 2 would read said Mark built house, and now the defendant number 2 has started to construct his residential house by breaking down the said Mark built house after getting proper permission or sanction plan from the Panchayat authority. When the plaintiff has filed this case due to the previous judge with the defendant. Moreover, the father of the plaintiff number 1 and the husband of the plaintiff number 3, that is second sir, is residing at another place since in the month of December 1983, and he realized that it was not possible to him to construct a residential house which said little quantity of land of the said plot, and for such he delivered his share to the owner of the said plot, and he got equal quality of land over plot number second sir. Travel with regard to this exchange. Travel, I bow down. But with regard to 145 square of share having offshore share, he is basically universe has admitted to the presentation. I already got what is
Was filed for recovery of the money and also for other reliefs like their demand is bad and for allowing us to proceed. In the suit, we made an interlocutory application not to give effect to the used to sign the lease agreements with all the allottees. They have not terminated the contract. So we move another application that you cannot deny your obligation under the clauses of the contract, which you have not yet terminated. So from that, whatever refusal or non-concession of that interim order, the appeal was preferred to two appeals preferred, one from the first order and one from the second order. Or she made it clear, first order is concerned, I will not interfere.
That was because they're not claiming, restraining them from claiming.
That. But second order, Lordship was considering because they have not terminated the contract. They have not disowned.
That was for to restrain them from terminating, giving effect to that letter.
Of demand, yes. And the second one for letter of that letter such that they go on executing the agreements with third parties because I am not, because they are now claiming from me and from them also. And they just can't penalize that. So on that part, Lordship was kind of expressed your mind in our favor, but then they took the point that this is a commercial suit. And Lordship, I said, and Lordship thought there was some merit in the point, so I said I'll come with the judgments. Lordship, coming to Commercial Courts Act, Lordship, this will be coming under Section 2(1). It can come under 6, 7, 11, and 15. Of course, I gave a small preliminary point in that.
Oh, thank you. Yes. Yes.
But from May or early June, summons was served, notices served. They have not applied for any return of plaint or rejection of plaint. Now, Lordship, firstly, construction and infrastructure contracts, that's Roman 6, including tender. Here, there was a tender. This contract involves construction and it can be infrastructure also because residential complex for all kinds of. 7, agreements leading to immovable property. Certainly, it is covered by this. An agreement related to
used exclusively in trade or commerce.
That will be the question whether the
residential can come within that.
But that is very clearly covered by Ambala Sarabhai judgment. Used means used on the date of the agreement. So that will not make it because that was a barren land on that date. The next category as they submitted is 11, joint venture agreements. Because they are giving the land, I am developing, whether this is a joint venture agreement. And going by that, maybe 15 may also be relevant, partnership. Though joint venture and partnership, because this agreement has sporadically used the word partnership also.
It has used.
Partner. So, under which one? My submission will be, it will be under 7. Because this is neither a pure construction contract. Construction contract, certainly not.
Well, not a construction contract. It's purely a construction contract.
Those I will cite my judgments to show that pure construction contract is where somebody engaged the contractor to construct a building or some structure and he gets remuneration for that.
You have also certain rights to sell and all.
I have absolute right to sell, develop, and to exercise my rights. So this is not a pure construction contract. Certainly not a pure infrastructure contract because LIG, MIG, I am selling freely. There's HIG, MIG, I'm selling freely. LIG also, they do the lottery. I get the money.
All right.
Third category is joint venture, but doesn't have any of the legally attributed, legally held attributes of a joint venture. They don't supervise the project. We do it exclusively. They don't have any share in the profits.
They have given the land. Their
Land-
investment is by way of the land.
Land is their contribution. Could be. So now that will be a question whether it's a pure joint venture.
Capital sort of contribution. It's in the nature of a capital.
So that has been discussed here because the construction and joint venture both cannot be. Construction, I am paying them money for building on their land,
All right.
for spending on the land. Joint venture, they have none of the attributes of a joint venture, though the word partner has been used.
See, in the agreement, Mr. Mitra,
Let's see the agreement.
place the worst clauses against you.
Worst clauses against me.
Yes.
Let me start with that.
Yes, because that will make matters easy. Because
That'll
in
make-
any event, Mr. Chatterjee would
It has got everything in one clause. That is, I will tell you.
very well. You show your favorable.
Yes.
clause of
Page
second.
2, Lordship kindly. No, I will show the worst because
Both,
it's always
both,
best to
No difference.
start with what is against me.
Yes.
Lordship
better.
kindly come to page 26 in the recital. The fourth para from the bottom. And whereas the party of the first part was desirous of undertaking the work of development of residential
This is
infra,
paragraph. Sorry.
the fourth from the bottom. And whereas page
26.
26 of
Yes.
318. FMA 318. That's the later MA. Later FMA. That's item number 4. Sorry.
P18.
FMA 3182.
No.
FMA 1485. FMA 318. FMA 318. Page 26 in the recital.
Yes. Fourth paragraph.
Fourth from bottom. And whereas the party of the first part was desirous of undertaking, first part is ADDA, the other side, undertaking the work of development of residential infrastructure on the said land in partnership with a private developer stroke partner. This is, according to me, the worst against me. Worst against me. It has got elements of all of it.
Yes.
Then, my lordship, kindly come to the bottom of the page.
Yes.
And whereas the party of the second part submitted its expression of interest against the invitation of the party of the first part. And whereas the party of the second part became the successful bidder. So it's tender again, Roman 6. Then lordship kindly comes to operative clause 1. The party of the second part shall pay to the party of the first part land premium. This is the reverse of construction, reverse of interest. For the said land at the rate of 15 lakhs per acre at the time of immediately prior to execution of these presents, in pursuance whereof the party of the first part shall hand over permissive possession of said land to the party of the second part simultaneously with the execution of these presents for construction of residential infrastructure. Roman 6. Now, lordship kindly comes. Then comes, may I show, this is basically the damaging part against me. Now, kindly come to clause 5. The party of the second part shall be responsible for preparation of detailed planning, engineering, estimates and structural design. The party of the second part shall thereafter get the same approved by the party of the first part. That's also somewhat against me, approval. Party of the second part shall undertake feasibility studies, market survey, etc. 7 is very important. The party of the second part shall finance and execute both the remunerative and non-remunerative components like the roads and other parts of the project as explicitly stated and appended in the terms of reference issued by the party of the first part at the time of inviting of tender. The party of the second part shall execute the project in accordance with the guiding principles of the project as set forth in the details in the terms of reference issued by the party of the first part. So. Then time period is clause 9. Then 10 again uses the word partner. Clause 9 is the time period.
Partner infrastructure project for promotion and marketing.
Yes. That's again a blended partner infrastructure.
Commercial.
Now, 11 gives an absolute right to be sell, for me to sell the project. 11 and 12. 11 and 12.
Yes.
Party of the second part shall market the remunerative portion bill project to prospective parties, and then 12, party of the second part will have sole discretion and prerogative to market the remunerative part and to determine and realize the premium of the developed residential plots, bungalows, etc. Then again, I have to pay. Clause 13.
It's a Mitra, apparently it's a commercial.
Commercial lordship, that is the whole cash, my lord. That's how Roman 6.
For building a project, there is a partnership between you. You can sell a part of the property, and obviously it's for money. You are not doing it gratis. None of you are doing it gratis. It's a project. It's a commercial project, but the purpose of user by the end users would be residential. But the project vis-a-vis you two,
That I'm
it's
making
commercial.
a profit.
You are making a profit. They are also obviously
They are
making
doing infrastructure work,
getting
something they are
out of
saying.
it. Yes.
They are getting some money out of it.
Construction
Well,
of a project.
They've got the hints of all
infrastructure.
the commercial. It smells of commercial. Smells of commercial.
Very
but
strong smell of.
Very strong smell. But then the Ambalal Sarabhai, Supreme Court Judge Lordship knows, has said that even if it smells of commercial, this is a act which is meant to be restrictive only if it comes exclusively within one of those clauses of Section 2C. And in the same breath, Ambalal Sarabhai says that this since the land was not used for commercial purpose. For example, if I develop a property in, say, Alipo, a developer is engaged by a company to develop the property. It's all commercial, no question of infrastructure also, so it's nothing but commercial.
So we to cite the judgments, the relevant portions, because this is all. I mean, the injunction, you are saying that the court refused any other ground. I mean, you can take that also apart from commercial.
Well,
even if you win on the commercial aspect, or let us decide the commercial aspect.
Well, commercial is against me because then I have to go to the commercial court. But there also, then I would like to cite that if I don't succeed, that the interim order should not go because it is a matter of transfer. You just cannot. I mean, that cannot, especially when there's a gray area. Then there are judgments of our court, there are orders of our court, which
or rather the interim order should go.
There's no interim order here.
Yes.
So I'm asking for an
interim order should not. It should go. I mean, we should set aside and give away an injunction, and that. Transfer at best.
I'm not that pessimistic on the on the commercial part. So let me not think about that part later. Ambalal take down. Let me first side Ambalal Sarawai. আনিনি আম্বালা আম্বালাল আনতে দাও তুমি আমি আম্বালা দিয়ে দিচ্ছি আম্বালাল দিয়ে দিচ্ছি তোমাকে আছে তোমার কাছে দাঁড়া আমি তো এক্ষুনি দিই can you give me 1 minute let me give the Ambalal judgment.
You just give me the citation of
that is so obvious so possibly I did not give it to you. My Ambalal Sarawai to reference বলে দাও 2020-15 SCC 585 2020-15 SCC 585.
Don't even have one copy or
one on my iPads we have, but then that তোমার iPad আছে দিয়ে দুটো iPad হ্যাঁ আমি দিয়ে দিচ্ছি তোমাকে kindly give me 1 minute while they get the copy.
Connectivity we are not getting connectivity কি হলো আচ্ছা এবার আসছে connectivity
iPad 9 তো ঠিক আছে দিয়ে দাও. You may start with
just give us half a minute, Mr. Mitra. Will just connectivity is it's an issue here. Connectivity আসছে না.
Will we airdrop it to my lord?
No, this is no. We can find out. The connectivity is an issue for us.
So then I can airdrop it to my lord's iPad. Airdrop.
We'll just do it. Give us half a minute. আছে ওয়াইফাইটা কিছু করা ছিল নাকি অন্য ওয়াইফাই ছিল কানেক্টেড। ও page number was 5.
585.
Right.
2020 15 SCC. আমি তো জজ পেয়ে গেছেন জজ সাহেব।
Yes, we have.
আমার থেকে বলছি।
Yes, sir.
Now should kindly come
Yes.
para 4. Accordingly, a mortgage deed was executed, but the same has not been registered. It is in that light, the appellant herein filed commercial suit so as to enforce the execution of a mortgage deed. Consequently, the reliefs, etc., etc. Now, Lordship kindly comes to paragraph. One paragraph, bolo? The judgment of justice. Lordship, may I show paragraph 14 first?
Yes,
That is a common trait in every judgment. In that view of the matter, it is also necessary to carefully examine and entertain only disputes which actually answers the definition of commercial disputes as provided under the contract. In the instant case, as already taken note, neither the agreement between the parties refers to the nature of the immovable property being exclusively used for trade or commerce as on the date of the agreement, nor is there any pleading to that effect in the plea. Here, it
So
can't
the
be.
date of agreement that are.
Date of the MOU. That date was vacant land. I don't think anybody can possibly
Yes.
argue. Now, Lordship kindly comes to Justice Bhanumati's judgment.
Mhm.
37.
Yes.
A dispute relating to immovable property may per se may not be a commercial dispute, but it becomes a commercial dispute if it falls under subclause 7 of section 2(1)(c). The agreements relating to immovable property used exclusively in trade or commerce. The words used exclusively in trade or commerce are to be interpreted purposefully. The word used denotes actually used. It cannot be treated either ready for use or likely to be used or to be used. It should be actually used. Such a wide interpretation would defeat the objects of the Act and the fast-tracking procedure above.
Yes.
Now, 39. It appears that the trial court proceeds so after Placeta B. One line after. As rightly pointed out by the High Court, there is nothing on record to show that at the time when agreement to sell came to be executed in 2012.
We are satisfied on 7.
On 7, and it should be given a restrictive meaning.
No, we are satisfied on clause 7. On that date, it was not in use, so that
no,
is
I mean, there's also
other points.
There's also a finding that it should not be it should be restrictively interpreted so that every dispute cannot be a commercial
On the date of use.
No, I mean
That's on 7. That's on 7.
No, generally section 2(1)(c) should be strictly interpreted so that it can be widened. It can be so that only those cases which come and not a wide interpretation for any provision.
Right. Yes.
That is paragraph 36, placetum G. Placetum G of paragraph 36. A purposive interpretation of the statement of objects and reasons and various amendments to the civil procedure codes leaves no room for doubt that the provisions of the Act require to be strictly construed. If the provisions are given a liberal interpretation, the object behind constitution of a commercial division putting the matter on fast track only for the records, and speedy resolution of commercial disputes will be defeated. If we take a closer look at the statement of objects, such as early and speedy, have been incorporated and reiterated, the object shall be fulfilled only if the provisions are interpreted in narrow sense and not hampered by the usual procedural delays plaguing our. So narrow sense has to be interpreted. Now let me come to a judgment.
Purposive interpretation for a narrow literal construction.
Not liberal, because this should be restricted to only
Contradiction in
those
terms, Mr. It is binding. Article 141 is. So you win.
Lordship need not say that. Lordship, the next.
You have to see a purposive interpretation of the strict rule of construction. But very well. This judgment is there. So on 7, and generally you are saying 2-1.
Now let me come to specific judgments on specific judgments on the construction contract, development agreement,
right,
and yes. May I start with Ramesh Shatadao?
Just give us the citations before you start so that we can.
I'll just place the relevant para and that's.
No, the site.
Yes. No. We have copies. We have copies.
You have copies?
Yes, of course. That's there's only one. Hopefully they have not got. Others they have. That's something I took it for granted. They'll be happy.
So we are logging out.
Yes, absolutely, man, absolutely. Rameshwar development, that is, we have given them 2022 koto?
2020. 17 SCC.
17 SCC, page 1. Lordship, kindly come.
You can just give us the paragraphs before you start so that we'll take a note and then we can.
Yes.
Or you can place the paragraph.
No, Lordship, may I just
on the run we'll do it.
No. I will assist my lord. I will assist my lord. Any collaboration agreement involves an element of transfer. That is paragraph 26.
Mm-hmm.
26, and the conclusion is no. 25 SCC. I was to 25 there, and the conclusion is
25 is also not there.
It was urged on behalf of Godrej by the.
Oh yes, that's there.
And let me just see. It was urged on behalf of Godrej that entering into collaboration, applying for license could not be construed as transfer. So whether it was an agreement for transfer or not. So agreement for transfer, there's an element of agreement for transfer.
You're reading para 25.
That's no. That's the question raised. Now the answer to it. The answer to it is in paragraph. 35. Just a minute. 35. The collaboration agreement. Nature of collaboration. Sushil Kumar Agarwal pore. 38. Para 38. Collaboration agreements which enable the colonizer developer to retain a significant portion of consideration, here entirely, are not in the nature of pure construction contracts. And the read with the previous paragraph is very important, where Ashok Jaiswal was quoted. That is para 37, our full bench judgment. That this is a different class of contract. Not merely construction, not merely developers, a different class of contract. That is really, here it starts, Ashok Jaiswal, Placitum. It really starts at page 22, Placitum. D onwards.
Is the italics portion.
Italics. Now that is here. May I pause here for a moment?
That is the three judgment judgment.
Bench.
The Banerjee's judgment.
Yes. Where it was given a different class altogether. This is neither a construction, nor a transfer, nor a joint venture, but different class. And that's why, my lord, there was the introduction of entry FF to entry 5 FF. Still then, it was getting away with 100 rupees stamp duty. A joint venture agreement, because it was neither an agreement for sale nor leading to agreement. A different class had to be created, a different stamp duty category had to be created. 75,000 rupees for joint venture. 2012 that came in, amendment. So it's such a different class. Now Lordship kindly goes up a bit. Now, Sushil Kumar Agarwal, where it is quoted, Lordship, very 36, 36 money? Yes, 39 is very important. 38, 39 both. Thus, 38 first, thus collaboration agreements which enable colonizer developer to retain a significant portion of the constructed area as consideration are not in the nature of pure concession contracts. An analysis of these agreements depict the transfer of crucial rights and interest in the property which otherwise are enjoyed only by the landowner, falling short only respect of title. Sushil Agarwal, this court stressed on the necessity to analyze the terms of a collaboration agreement in order to determine if any charge or interest had been created in the land. If so, such agreements attract specifically. Section 17, paragraph 17, development agreement has not been defined statutorily. In a sense, it is a catch-all nomenclature, which is used to describe a wide range of agreements which an owner of a property may enter into for development of immovable property. As real estate transactions have grown in complexity, the nature of these agreements have become increasingly intricate. Now, Lordship kindly turns the page to the next page of Sushil Kumar, to the next page, the quoted paragraph 18.
Yes.
When a pure construction contract is entered into, the contractor has no interest in either the land or the construction which is carried out. But in various other categories of development agreements, the developer may have acquired a valuable right, either in the property or in the constructed area. Terms of the agreement are crucial in determining whether any interest has been created in the land or in respect of rights. In a construction contract, the contractor has no interest in either the land or the construction carried out on the land. But in other species of development agreement, the developer may have acquired valuable right either in the property or the constructed area. There are various incidents of ownership in respect of immovable property. Then the next paragraph 40. That is what I was starting with. That is recognition of transfer of certain rights in the property. Now, next I go into joint venture. Yes. Next I go into is joint venture, that is Fakir Chand Gulati. Where Fakir Chand Gulati is quoted, that is Fakir Chand Gulati, it is 35, paragraph 35. 35 issue. The nature of collaboration agreements has been discussed by this court in Fakir Chand Gulati. In this case, the parties had entered into a collaboration for the construction of residential building. Para 35.
Yes, 35.
The nature of collaboration has been discussed by this court in Fakir Chand Gulati. In this case, the parties had entered into a collaboration agreement for the construction of a residential building. The usual conditions such as handing over possession, non-interference in the project, handing over title documents to enable sale of constructed units to third parties, etc., were agreed to, holding that the Consumer Protection Act was applicable to collaboration agreement and that the parties could not be viewed as joint venture. Given the power inequality between them, this court held as follows. What then is the nature of the agreement between the appellant and the first responder? The appellant is the owner of the land. He wants a new house, but is not able to construct a new house for himself, either on account of paucity of funds or lack of expertise or resources. He therefore enters into an agreement with the builder. He asks the builder to construct a house and give it to him. He says that as he does not have the money to pay for the construction and will therefore permit the builder to construct and own additional floors such as consideration. He also agrees to transfer an undivided share in the land corresponding to the additional floors which falls to the share of the builder. As a result, instead of being the full owner of the development with an old building, he becomes a co-owner of the land with a one-third share in the land, an absolute owner of the ground floor of the newly constructed building, and agrees that the builder will become the owner of the upper floors with corresponding two-third share in the land. The cost of the undivided two-third share in the land, which the landowner agrees to transfer to the builder, is more than the cost of construction of the ground floor by the builder for the landowner. They also mutually agree that the builder will pay so and so cash. The basic underlying principle, purpose of the agreement is the construction of a house or an apartment in accordance with the specifications by the builder for the owner. The consideration for such construction being the transfer of undivided share in land to the builder and grant of permission to the builder to construct two floors. Such agreement, whether called a collaboration agreement or a joint venture agreement, is not, however, a joint venture. There is a contract for construction of an apartment or house for the appellant in accordance with the specifications and in terms of the contract. There is a consideration for such construction flowing from the landowner to the builder in the form of sale of an undivided share in the land and permission to construct and own upper floors. To adjust the value of the extent of land to be transferred, there is also payment of cash consideration by the builder. But the important aspect is the availment of services of the builder by the landowner for a house construction, for a consideration. To that extent, the landowner is a consumer, the builder is a service provider, and if there's a deficiency in service in regard to construction, the dispute raised by the landowner will be a consumer dispute. Last four lines of this: the deciding factor is not the number of a partner's deliverable to the landowner, but whether the agreement is nature of a joint venture or whether the agreement is basically for consideration of certain area of the landowner. The above judgment in Uppal agency's case, while clarifying the purpose of collaboration agreements, falls short of delving into the legal effects of the transfer of such development rights, parting with rights which are fundamental to ownership for valuable consideration in landowner is a common feature of such collaboration. Given the evolution in complexity of real estate contracts and the absence of the definition of collaboration agreements in legislation, their interpretation by the various high courts assumes significance. In a question pertaining to the applicability of the Specific Relief Act, a full bench of the Calcutta High Court, Ashok Kumar Jaiswal, addressed the nature of a development. There, as I had shown, it is a different category altogether. Neither a joint venture nor a construction involves some transfer. तो देखिए दिला
Yes, Mr. Mitra, any other judgment?
Next, yes. Well, applying this
Yes.
to Commercial Codes Act, I would first place Sanjay 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 Bombay High Court Sanjay Suganchad Kasliwal. अजय को परिचित तो दिए ना ठीक है kindly come to
Mr. Nayak, be ready with the next judgment in the meantime. Yes, Mr. Mitra.
Paragraph 19. Yeah, multiple area. Ambalal, may I just hand up? This is the Ambalal Saravai. Paragraph 19 is Sushil Kumar Agarwal Development Agreement. Okay, paragraph 20.
Yes, sir.
20 and 21. The Honorable Supreme Court in the above case, since Sushil Kumar Agarwal has held the pure construction contract. The contractor has no interest in either the land or the construction which is carried out. But in various other categories of development agreements, the developer may have acquired a valuable right, either in the property or in the constructed area, and the terms of the agreement are crucial in determining whether any interest is created. And Lordship, paragraph 21 also. This has been applied in the context of commercial courts act matters.
What does the court hold? I mean,
court has held no, this is not.
by no stretch of commercial imagination, this is a simple construction contract.
not Litigation लिखा था Fakirchad Gulati আমি কটা অন্য প্যারাগ্রাফ দেখাবো আগে Fakirchad Gulati I want to show a few other Lastly, I'll come to our division bench applying 2(1)(c), Roman 7(2), even a development agreement. Now, my Fakirchad Gulati, Fakirchad Gulati, I want to show paragraphs 23 to 25. (20) 21, yes. That is our parent judgment on joint venture. New Horizons case. Para 20.
Yes.
New Horizons case, the expression joint venture is more frequently used in the US. It connotes a legal entity in the nature of a partnership engaged in the joint undertaking of a particular transaction for mutual profit or an association of persons or companies jointly undertaking some commercial enterprise where all contribute assets and share risks. It requires a community of interest in the performance of the subject matter, a right to direct and govern the policy in connection therewith, and duty which may be altered by agreement to share both in profits and losses, according to words and phrases. The following definition of joint venture in American jurisprudence. A joint venture is frequently defined as an association of two or more persons formed to carry out a single business venture for profit. More particularly, it is an association of persons with intent by way of contract, expressed or implied, to engage in and carry out a single business for joint profit, for which purpose such persons combine their property, money, skills, and so, creating a partnership, a corporation, or other business entity pursuant to an agreement that there shall be a community of interest among the parties as to the purpose of the undertaking, and that each venturer must stand in the relationship of principal as well as agent as to each other, co-venturers, within the general scope of enterprise. Joint ventures are in general governed by the same rules as partnership. The relations of the parties to a joint venture and the nature of the association are so similar and closely akin to a partnership that their rights, duties, and liabilities are generally tested by rules which are closely analogous to and are substantially the same, if not exactly the same as those which govern partnerships. Since the legal consequences of a joint venture are equivalent to those of a partnership, the courts freely apply partnership law to joint ventures when appropriate. In fact, it has been said that the trend in the law has been to blur the distinctions between a partnership and a joint venture, very little law being found applicable to one that does not apply to the other. Thus, the liability or torts of parties to a joint venture is governed by law applicable to partnership. A joint venture is to be distinguished from a relationship with independent contractor, the latter being one who exercising an independent employment contracts to do works according to his own methods. Then paragraph 23. To the same effect is corpus juris secundum. Joint venture is a term interchangeably and synonymously with joint adventure or co-venture, which has been defined as a special combination of two or more persons where some specific venture for profit is jointly sought without any actual partnership or corporate designation, or as an association of two or more persons to carry out a single business enterprise for profit, or a special combination of persons undertaking jointly some specific adventure for profit, for which purpose they combine their property, money, effects, skills, and knowledge among the acts or conduct which are indicative for joint venture, no single one of which is controlling in determining whether a joint venture exists, are joint ownership, control of property, sharing of expenses, profits and losses, and having and exercising some voice in determining division of net earnings, community of control over and active participation in the management and direction, intention of parties expressed or implied, fixing of salaries by joint agreement. Black's Law Dictionary, joint venture, a business undertaking. Now, a business undertaking by two or more persons engaged in a single defined project. The necessary elements are an express or implied agreement, common purpose that the group intends to carry out, shared profits and losses, each member's equal voice. May I pause here for a moment and see the attributes to those one in placitum B, whether any of them is there. Joint ownership of and control of property. Ownership remains with ADDA, and there is a transfer to the ultimate purchaser. Control of property, I remain in exclusive control. No permissive possession, but I develop till they terminate. Then sharing of expenses, 0. Profits, 0. Losses, 0. Exercising division in earnings, 0. They get the land price. Then community of control over, that I have shown, my lord. They have no say over my construction, my choice of contractors, architects, engineers, my sale, etc. There's no community of control and direction of business enterprise. I do it exclusively my way. They are only interested in the money and the timeline that is also translated into money. Delay you can do, but pay me certain money. It's entirely monetary. Fixing of salaries, nothing. That's all entirely my exclusive domain. Now, coming to joint venture. So this is not a joint venture in the sense.
You have paid a premium for the land.
To something like
that amount was
paid. Firstly, a lump sum and then installments. That has been paid. Nothing more.
You pay for the land, you take the land, you construct over that, exclusively your domain. Then the flats which are created there, some you sell, some they sell.
No, entirely I sell. Some they have a say, like the 20 plots. They have a say who it will be allotted to, and the LIG. They will. It is by lottery, but that's not more than 10% of the project value. By lottery, but that I sell as per lottery and I get the money. They have no say.
So what do they get from this project?
Money. Nothing else but money.
The land, the price of the land, and those control over those LIGs and all.
Control over the LIGs, as in
they can sell the LIGs.
No, they cannot sell. I sell, I get the money from LIG.
They have
they do a lottery system for the LIG. Money entirely comes to me.
But the project is a public project. Isn't it not an infrastructure project?
HIG.
Because none of the judgment deal with the infrastructure aspect of the matter.
HIG, MIG.
We can understand the difference between construction and development, Mr. Mitro. We are rather clear on that.
Yes.
But infrastructure is also one of the components of this 6.
Well, is it an infrastructure contract? That's the question now. Is it so? If
It's a housing project, LIG, MIG, HIG.
Now let's come to the specific relief act, where we have got the infrastructure, some indicator as to what can be an infrastructure that is
The
scheduled by the
infrastructure specific relief act does not constrict the definition in the Commercial Codes Act.
no.
That's public. Yes, that's public infrastructure, but here infrastructure is not, the definition is not equivalent to that.
Except that affordable housing is also there in the
Affordable housing is there.
that is there in the
That is
specific
there.
relief act.
That is
Now affordable housing here 50% is the J.
50% is affordable.
50% affordable. Here not even 10%. I paid 20 crores odd, got the land. 50% affordable comes under, though that's not public really, but affordable, 50% affordable is infrastructure. Now, will it infrastructure? Some indication from there. And certainly not an infrastructure contract, because infrastructure contract will not include my HIG. I sell it at whatever price I want to, my MIG. There may be a part of it, may be infrastructure. If you take out the LIG separately, that if that's a separate project by itself, that could be infrastructure contract. The contract is not infrastructure. Now I come to, and Mala, this is not a case where this should not be tested before the first court first. They should have taken this point because they had 6 months time to apply for rejection of claim. They did, we were served on them by first week of June.
Commercial court objection was not taken at the time of hearing. This is ad
No,
interim.
this is ad interim. But second day they were there, but they have not given their objection in spite of time expiring long back. But they normally there, it's order 7, rule 11 should be filed or rule 10.
They took this objection in the objection.
No, objection not yet filed. Objection not yet filed. They are.
But this will be subject matter
for order 7 rule
also.
Order 7, rule 11 or not rule 10, because that is
irrespective of their filing that.
Yes, partly
we can do that sitting.
Yes, at the ad interim stage, that could be a prima facie case. No, that could be a relevant factor. So,
if it's a question of transfer, then maybe not rejection of claim. Maybe not.
There also, again, that's another territory where
Section 15 is there and other sections.
15 is a pending suit.
Yes.
Pending suit in 2000.
Pending suit now.
In the year 2000. So, my lord.
No, what about the new suits? They're directed to be transferred also under section.
No. 15 doesn't. In fact, the latest Supreme Court judgment, Ase, what is the name? Ase, na? Ki Ase. Peculiar name. Yes. The latest Supreme Court judgment, I have to says it has to order 7, rule 10 is applicable. So that will not make it inherent lack of jurisdiction. Order 7, rule 10, only remedy is return of claim. Lordship, may I just hand the floor to what? iPad ta kholo na. Or it was iPad. Lordship, may I just ask it a partida? Or iPad 9, Ritu's iPad to judge show kuch. But you see the latest Supreme Court judgment as to what should be the remedy in case of suit being filed in the wrong division. That very recent. It's
the 15 is only in respect of suits pending before
only pending. Order 7, rule 10.
The editing option is open, so I probably edited also. Not saved. 7-11 actually.
No, my iPad is safe. I just transferred to them. Returned under order 7, rule 10.
Yes, this is vis-a-vis rejection. I mean, it cannot be rejected. Plaintiff has to be rejected.
Yes, paragraph 7 has to be returned.
Not rejected. As opposed to rejection, it has to be returned. But that does not mean it cannot be transferred.
Transferable, that's something I I have been arguing, in fact, in the original side, why should not be transferred? Because
Yes.
sometimes, especially in our High Court, when it is from, I have got those series of orders where Justice Shonji Banerjee would be simply transferring from, and there was urgency when one moved it, simply transferred it. I have got those orders, but again,
There are orders either way, return of plate and transfer. But
a division bench recently, in my case, this is nothing but transfer, but that's in the High Court. High Court has both commercial division and non-commercial division.
yes.
Here, it's a different court. Though there also practical orders are there.
This is the same. Principle should be the same.
Should be the same.
You say section 15 applicability.
That I cannot say, because 5015 is expressly for pending suits, but inherent powers of court is what. There are judgments of Delhi High Court where in another case I argued that this return of plaint, I got the court division bench held in our favor somewhat, but then again with the interim orders returned and transferred. But it is as good as transfer, but then might as well return it. And with all the orders, everything was transferred. But this is again a different court, so different. This is not Alipo court.
Yes.
Alipo commercial. It's not a different division of the same.
Alipur,
But the Alipo commercial court has determination over many
several.
districts. So strictly not two divisions. I can show just now offhand few orders of transfer in Barashat court from one court to the other, or to commercial division in the 227 jurisdiction by Justice Shonji Banerjee. So this point was taken. Then let me transfer. Let me not waste time on that. So
27 you can do that. 24 also, so would you can do that.
yes, that's I personally feel these technical legalities should not come in the way of rendering justice. So now, on our lordship, now this applied in case of now Lord Grier Nadagoral Alshi.
How many more judgments do you have?
Few more, lordship. Since this
Cite too many. I mean, just on the relevant points. And if it's not necessary, then need not.
no, here it was a development agreement, but even then the court applied Rule 7. I mean, or that clause 7. Paragraph 14.
This was a demurrer application.
Yeah, I mean, yes, a demurrer application. So on an application, it was a development agreement case. And you must take it as a demurrer.
Why are you citing this for
Because this was Rule 7 was applied.
Rule 7, first Rule 7.
Rules apply. Paragraph 15, even though it was a development agreement. Though there was not much discussion, but if you see paragraph 11, this is a development agreement.
Yes, but this is for what proposition?
So even if it's a development agreement, Rule 7 is the omnibus. Clause 7 is the omnibus clause which relates to all agreements related to immovable property. If it does not fit into the category of either pure construction, pure infrastructure, pure joint venture, then certainly it will come under clause 7. Clause 7 because it relates to an agreement relating to immovable property. That is the omnibus provision when the specific.
You have already cited as a Supreme Court judgment on this proposition.
May I just then wrap up quickly? A specific judgment of our High Court, though single bench in development agreement case, Abdul Rashid Dao, where the court held development agreement is not a paragraph 20. Sorry, then paragraph 21, 22, and paragraph 23. Cannot be a joint venture, paragraph 20. Though this is pending in appeal. It's pending in appeal. No, there's no appeal from this.
Yes.
This is really odd.
So, Mr. Mitra, would you like to also argue on the other points before we go on to them? Because it can be several ways. I mean, suppose we uphold his objection and say that the plaintiff has to be returned and gone. Suppose we uphold his objection but hold that it should be transferred with the order. Then we have to look into the merits of the order otherwise. So make all your arguments and comprehensively, and they'll deal with everything.
May I then show?
And we are making it clear. We'll admit the appeal formally today, and we are hearing the appeal itself, Mr. Chatterjee, along with that maintainability point. Because nothing will be left in the appeal then if you keep it pending.
She kindly comes to page 30.
You are addressing us on 1485, if I may.
Yeah, 1485. কোথায় লিজ এক্সিকিউট করবে কোথায় আছে বল? Yes, page 30. It starts from page 29. Continuation of clause 11.
Yes.
At the very top, the developed flats, apartments, residential plots, commercial spaces will be disposed of by tripartite agreements, lease executed by and between the party of the first part, the intending purchaser, and the party of the second part. Initial tenure. So they will execute these tripartite agreements. They have not terminated the contract. Then, and 12, as I had shown 12 in another context, the party of the second part will have sole discretion and prerogative to market the remunerative property and to determine and realize the premium of the developed residential plots, bungalows, multi-story building, and commercial spaces without any objection and claim and dispute of the party of the first part. Lordship kindly come to the middle of it, subject to the stipulation relating to fixed premium and mode of disposal in respect of 150 LIG and 20 residential plots. Now, so far as that is concerned also, the defendant, we had been requesting defendant from 2017. Lordship kindly comes to page 85. Page 85, where, sorry, well, page 80, yes, page 85 is first. On page 86 is first. Page 86 is where I write on 5th September 2016. Kindly come to page 87. Please conduct the lottery. Paragraph 3 of page 87. To that they agree at page 85.
At page 85?
84. 84, we write 6th May, yes, once again we write 6th May 2016. We request you to kindly proceed with the finalization of the 150 LIG flats, the reserve plots brochure for our PP. So we like to proceed with the lottery.
Page 86 is subsequent to 84.
Yes, well, 80. Well, first 84, then 86, yes. Then comes 85. Now, so my request for lottery has been going on. Ultimately, they did the lottery as late as in page, they did the lottery only in, yes, page 99.
Now they have sought to terminate this agreement.
No, they have not terminated. That's the whole point. They have not terminated. The agreement is still there.
Withholding the signatures.
Withholding the signature. They have a money claim on case of liquidated damages, which they have to prove and get it. Their simpliciter lottery was done in 1999, long after the delay. 2004 or 2024, page 99. 24, page 99. Lottery was done, and the names, they asked us to process the application. We give them the flats. Now, we've got the money. I have no monetary gain from it anymore. But they will, now they've suddenly stopped executing the agreements. And now what I challenge subsequently is the one at page 227.
Relevant portion 229, third paragraph.
Is page 227, second volume, at page 229.
Yes.
The last bullet.
Literally.
The acts done so for by you proves that dues of Adda have not been paid by you. That is the penalty.
Yes.
Within sufficient time, which compels Adda not to execute any lease deed any further in your favor. And Lordship, that just as you close with that clause which entitles them to that compensation is, Lordship, clause 9 of the MOU, that is at page
29.
page 29. Page 29, the party, clause 9, party of the second part shall execute the project within a period of 4 years from the date of receiving necessary sanction from all concerned authorities. Now, see this in the light of their application made at page 71, which is still pending. Page 71. And it will never be possible for me to complete, because commercial part, and they'll go on levying indefinitely. They have themselves applied for conversion of a part from commercial to residential. Can you see the second paragraph of page 71? Subsequently, the developer informed this authority that the commercial project within the Sugam would not be feasible due to lack of prospective customers, and hence change of land use was proposed for this portion. It may kindly be noted that development of MIG, HIG, buildings, LIG scheme and plots with a curb has been completed by the developer over the major part of the land. Also, a penalty of 2 crore 15 lakhs has been imposed upon the incompletion of the project over 28.5 acres. Master plan with project report submitted by developer has been enclosed herewith for perusal. Moreover, a waiver penalty. And last paragraph, approval be granted for taking necessary action to this end.
There was no prospective customer for commercial projects in this area.
So that we both found. There's no prospective customers. So this is still pending.
Anyway, yes.
And then there is one more letter. No, on this. No. And now that is the outcome, my lord.
Right.
And after receiving this 16th May 2025 that we will not execute, we made the second application. That is all. I'm good.
Good. So that's it. Yes, Mr. Charit.
Firstly, I need to answer the points raised regarding the maintainability.
Commercial.
Commercial. there are 3 to 4 clauses as my learned senior friend has already
Mhm.
indicated,
Yes.
in which can be beneficial for me actually. The first one is 2C subclause Roman 6. Construction and infrastructure contract, including tenders. And the next one is 7. Agreements relating to immovable property used exclusively in trade and commerce. And next one is joint venture and partnership agreements. Now, on the last occasion, emphasis was given on Ambalal Sarabhai's judgment.
Yes.
Whether this is the touchstone is that on the date of the agreement, or it should have been used for a commercial purpose. And the line of judgments of Ambalal Sarabhai and the subsequent judgments,
Yes.
they are all in respect of matters of specific performance of contract, or like, in which the bone of contention was there's a property in respect of which there is an agreement, say for transfer or for mortgage. Anything, I'm not going into the nitty-gritties of that. And the prayer made was you either execute the agreement, conduct a transfer, or anything. Now, the question that was posed before the different courts and the Honorable Supreme Court, say a plot which is a barren land, and I enter into an agreement with a third party without any cue that whether the property is used for a commercial purpose or not. Earlier it may be used. Ambalal Sarabhai say it has to be used. So in that case, a pure and simple agreement for sale, if I say that it will be used at some point of time for a commercial purpose, it will become a commercial dispute. This is the fallacy that the honorable courts had tried to prevent. As far as this agreement is concerned, this is a suit for recovery of money. Drawing the it's being drawn from the terms and conditions governing the joint venture between the parties. Say when to be concluded, and these things. This is not a suit for execution of anything that I need to do in respect of the property. So I am not putting emphasis on his Ambalal Sarabhai's judgment. I
don't understand the distinction between the two you are making.
My lord.
Please repeat. What
My
is the
lord.
distinction between Ambala Sarabhai and here?
Here, this is not, say, this is a property which is a barren land.
No, let us come to the language.
My
The
lord.
language is independent of the nature of the suit. We'll just come back, but we'll complete our question so that you can answer us. Now, here it says agreements relating to immovable property used exclusively in trade or commerce.
My lord.
All colors, all shades, all genres of agreements which relate to an immovable property which is being used as held in Ambala Sarabhai exclusively in trade or commerce.
My lord.
Undisputedly, this land regarding which this immovable property regarding which agreement was entered was not being used exclusively or otherwise for trade or commerce on the date of the agreement.
Had
so
it
whatever may be the context, whatever, now it was not being used.
Not being used.
So how can you invoke even this 7?
I am invoking the later one, that is joint
We'll
venture.
just come back and after 10 minutes and continue with that. Yes, in fact. Roman 6 is your best bet. The others apparently don't apply.
Roman 6 and Roman 11,
11 also, joint venture.
joint venture. My lord,
Joint venture, is it a joint venture? It's a pure development agreement. I mean, you give them to develop, they'll develop the property, sell off the flats, typical development agreement. Where is the jointness of the venture?
Lord, I'll try to show. She kindly takes up the memorandum of understanding for
Yes,
once.
we are there.
I'm taking up actually the FMA 1484. My markings are there. If your lordship kindly takes up there.
You place the internal page.
My lord.
We won't be able to
Internal page,
travel between two.
internal page 2.
Yes.
Internal page 2, the fourth paragraph.
Plus 3 actually. 8. Fourth paragraph, yes.
And whereas the party of the first part was desirous of undertaking the work of development of residential infrastructures on the said land in partnership with a private developer partner. Next, my lord, is in the page number, internal page number 4, clause 4.
Yes.
The party of the first part will provide the necessary assistance and logistic support in process of sanctioning of plan for the project and also obtaining requisite clearance from the required authorities, and shall also extend necessary help to maintain liaison with government agencies and statutory bodies for the purpose of water supply, drainage, power supply, and all other related matters relevant to the project. And my lord, the next point, 5. The party of the second part shall be responsible for preparation of detailed planning, engineering, estimates, and structural design. The party of the second part shall thereafter get the same approved by the party of the first part. But point 8, the clause 8. The party of the second part shall execute the project in accordance with the guiding principles of the project as set forth in details in the terms of reference issued by the party of the first part at the time of inviting expression of interest, which shall more fully appear from Schedule 2 hereunder written. The party of the second part shall also comply with the broad land utilization pattern, essential requirements of the project, and the engineering details such and such. The terms of reference issued by the party of the first part at the time of inviting expression of interest, the classification pre-bid meetings, and I'm not reading that. And my lord, thereafter, my lord, in the next page, the clause number 10.
Yes.
The party of the second part shall be authorized to use the name of the party of the first part as their public partner towards marketing of the residential infrastructure development project for promotion and marketing subject to the prior approval of the contents, advertisement, publicity, materials, etc. by the party of the first part. My goodwill goes here. Not kindly takes up internal page 7.
Yes.
Clause 14.
14.
The party of the first part. Am I with your lordship?
Yes.
The party of the first part shall have the right of overall supervision during the execution of the project. The party of the second part shall also indemnify the party of the first part against the quality assurance given by the Lord. I'm only relying on the first portion of it, that I have the overall supervision and execution of the project. And my lord, the next point, 15.
Yes.
The party of the second part will keep the party of the first part informed about the guiding principles in the matter of marketing of the developed property, the marketing strategies adopted in its furtherance, and the changes there to, if any, from time to time. Not more or less, these are the points. Now, in the all the judgments cited where the development agreement has been distinguished from joint venture, the main thing that makes the distinction is that I have a property, I give it to a developer, he constructs, I have no say in that.
Right.
I cannot also take part in the marketing portion of it. I am only concerned to the allocation of the owner, and the rest is been done by them. And the judgments from the line of Fakirchand Gulati and also Bunga Daniels, that was not cited, but I'll try to cite. All were considering whether the landowner is a consumer or not. Say whether the landowner is having a share in the profit or not.
Either from the perspective of stamp duty or from consumer.
My
other
lord.
consumer.
The landowner is having a share in the profit or not. So only
From the judgment cited specifically on commercial code by Mr. Vikram.
my lord, these Fakirchand Gulati, these were not
But
considering.
these judgments considered the others, HON'BLE and all. Anyway,
Yes.
so I get your point. We get your point.
But my lord, in that those judgments in which Fakirchand Gulati was relied upon, the dispute was involved in a plain and simple development agreement between a landowner and a developer. Here, in those cases, active participation in the business was not there. So,
All right.
my lord, I'll just rely on this Bunga Daniels judgment. It's a 2016 8 SCC 429. Though this was also while considering a consumer dispute. Well, paragraph 20. Same thing Fakirchand Gulati has been relied upon. And the emphasis that has been put here is whether I have an active, the landowner has an active participation in the project or not.
Paragraph 18.
Paragraph 20.
20.
My lord. May I read out? The obtaining factual matrix has to be tested on the touchstone of the aforesaid legal position. The National Commission has affirmed the order passed by the State Commission on the ground that the complainant is not a consumer as his purpose to sell flats and has already sold 4 flats. In our considered opinion, the whole approach is erroneous. What is required to be scrutinized is whether there is any joint venture agreement between the appellant and the respondent. The MOU that was entered into between the parties even remotely does not indicate that it's a joint venture as has been explained in Fakirchand Gulati. We think it is appropriate to reproduce the relevant clauses from the MOU. The apartment shall be shared by the owners and the builders in such and such proportion. The builder shall commence construction and complete the same within a period of 19 months. The builder shall pay 5 lakhs, and the next one, the owner hereby agrees that out of his 40% share. But I'm not reading it completely. Now the conclusion is that it's a 21. On a studied scrutiny of the aforesaid clauses, it is clear as day that appellant is neither a partner nor a co-adventurer. He has no say or control over the construction. He does not participate in the business. He is only entitled to, as per the MOU, a certain constructed area. The extent of area, as has been held in Fakirchand Gulati, does not make any difference. Therefore, the irresistible conclusion is that the appellant is a consumer under the Act. Not, I rely on this because it makes it very clear that the main thing that needs to be considered is whether I have any say in the project or not.
You have a say here in marketing, overall supervision, and also sharing your goodwill.
In my goodwill, because it's a perception that nobody knows Shugam Park, this entity. Everybody knows ADDA, and they're using our goodwill to get it marketed. And I have an active say in the marketing. It's a new creation altogether. This Shugam Park. My lord, even if this argument is not tenable, going that I'm making it clear, I do not have any share in the profit.
Yes, you don't.
I do not have any share in the profit, but I have an active participation in the business. And I want to make a distinction here. In Fakirchand Gulati and Bunga Daniels Babu and other judgments, they were considering not a consumer dispute, but a dispute that was brought before a commercial court, in a consumer court, not a commercial dispute. So there, the Honorable Court was only to look into that whether the person has a commercial interest having a profit sharing mechanism or not. Here the issue is completely different. Here I am a public entity. Whether I am building infrastructure, whether I am having an active participation in the venture or not, this has to be looked into. And my lord, if I also rely upon, my lord, clause 6 2H2C6, that construction and infrastructure contract. My lord, already my learned senior friend had cited this judgment of Sushil Kumar Agarwal, where a distinction has been made that what is the nature of a construction contract and development agreement.
Pakit Chand has been cited, and the
Sushil Kumar Agarwal was also cited.
Sushil was referred to in all those.
Referred to. So
Those judgments quote Sushil.
the ratio is, my lord, was before this honorable court. That construction agreement contract is one in which I engage somebody to make a construction, and that person has no say in has no transfer of any interest in the property. That's a construction
Yes.
contract. But even if technically this is not a construction, this is not a construction contract, there is a ingredient of infrastructure into it.
Here it says construction and infrastructure contracts.
My lord.
So you distinguish between dissociate between the two.
My lord.
You say separately construction and infrastructure contracts may come within this.
My lord.
It may be only an infrastructure or only a construction. Here it is both. Construction is to be made. So here construction as well as infrastructure contract.
But if I say construction contract, my learned senior friend will say that I am not creating any. It's construction contract is one in which I engage someone. He comes to make a building on my behalf, and I give him money, no interest in the property. So
here there was a tender process also.
There was a tender process. So tender and infrastructure, I come within the purview of this, and I'll show that he has to build roads and not to get any remuneration in respect of that per se is not transferring that.
So you see, in development also there is an element of construction. Plus this development, your rights are created and all developers' right.
My lord.
So therefore, construction had separate elements. Pure simplicity of construction with development, then it becomes a development agreement. And you are creating a third category. You are saying about a third category where it's construction as well as infrastructure. So irrespective of whether it's a development agreement or not, here there is an element of construction and infrastructure, and a tender process was involved.
My lord, I say joint venture as well as
joint venture is a different argument.
As well as infrastructure.
All right.
Because joint venture in respect of the properties that has been built, the units and everything. Infrastructure in respect of the sewerage treatment, underground drainage.
There has to be a construction.
In respect of a particular building, he builds a flat, sells it to other persons, may not be infrastructure in that respect. As far as this is concerned, this is a big barren area. He's building a sort of township in it. Infrastructure, sewerage treatment has to be made. Underground drainage is being made. Roads are being built. So it will benefit the area as well. And a public element is there. But I'll show those clauses in the contract.
Public benefit boundary wall and gated public.
Yes, show the clauses. And clause 10 says residential infrastructure development project.
My lord.
So not merely a residence, but an infrastructure
as well. Because it's a barren area, infrastructure has to be built.
Yes. But that would be appropriate for any building, any apartment. You have to create the sewerage and the adjoining road and whatever. That applies to any development agreement also. If you develop several towers, all these are development agreements. Suppose 4 towers are created and It does not become an infrastructure project by virtue of that. That is incidental to the residential complex. That much infrastructure, even if you build a cottage, you have to build.
But I'll show a few clauses. Kindly takes up internal page 17.
Yes, 17.
But here it speaks about that. Not 1, 2, 3, 4. Sixth point in bullet marked.
Sixth one.
Sixth point in
Yes.
internal page 17.
As per clause 5B?
Yes, my lord.
Yes.
Should compulsorily provide underground sewerage system with a treatment plant. The treated effluent of the treatment plant may fall into the master drain of the ADDA through the internal drainage system of the project. Internal, sir, আমারটা ওই আরেকটা বললো তো? এটা 17.
17.
Lord Counsel, even if a single tower is constructed, then also the same infrastructure are required to be made.
My lord, even if single tower is concerned, my lord, in respect of that may not be the underground sewerage treatment plant may not be made. Most of the case is being done by the corporation or the other entities. Here, because it's a public planning authority, it has to be done by us.
A previous bullet point also, evaluating, you will be the evaluating committee. Architectural control is with you. The immediately
lord.
previous bullet.
My lord, I'm grateful, my lord. And also in the earlier page, my lord, in page number 13 also, essential requirements of the project, part 2.
Yes, yes.
Here also underground sewerage system with a treatment plant. Street lighting has to be done by any developing agency. And so long it was, if it had been a per se simple development agreement, then engineering details, everything has been provided by us. Not Lordship will find in part 3 how they'll construct. They'll have to. Lord, in next point itself in page number internal page 13 itself, part 3, the engineering details. Shall do, my lord, may I read out? The private partner as a requirement of the project shall do the land development works. The design of road building structure should be in conformity with the specification and should factor in earthquake components.
That has to be in any project.
But specifications made by us.
No, specifications made by you previously. That's general specification. That's for all buildings which are constructed.
No,
Not for this particular project.
Not in respect of this project. We have already said that anything they need to do, they'll have to put it on our table.
What is this IST specification? IS.
My lord, which
In conformity with IS specification. What is this? That is the general specification for every building which comes up.
no, I stand corrected in respect of this, but in the
you wear two hats here. One is you are the general municipal authority there. So for all buildings, you make the town planning and all everything. Your requirements will be satisfied. But for this project, if it's specifically for this project, then we are required to look into it.
My lord, as far as ADDA is concerned, it's a authority under the West Bengal Town and Country Planning Act only looks into we are make a application before us, we'll issue a development permission.
Right.
And the other things, my lord, has to be looked into by the municipality or the corporation of the
So
locality.
therefore, you are not doing any of these.
No, this I stand corrected. This was wrongly indicated. But anything that has to be done, my lord, I already shown, my lord, it is there that in clause 18 and 9, say 15 and 16 is there that everything, first of all, marketing and whatever they do, plan has to be placed on our table. Not only the plan, because we are not the authority sanctioning the plan, that's the corporation. So I want to make out a case that I have an active participation in it.
So you say active participation is the important thing. Profit sharing ratio is one of the components, maybe. Here it is not there, but that's not a sole determinant.
My lord.
You have to have active control over the project.
My lord.
To be a joint venture.
My lord.
Very.
Firstly, an active participation, and secondly, there is an infrastructure element in it. Maybe because we are a planning authority, so they are suffering, maybe so that, but there is an element. And I'll cite only one judgment of the Honorable Andhra Pradesh High Court. Their judgment are there. Honorable Pradesh are there. Blue 9. Oh. As far infrastructure is concerned, I couldn't get a better judgment, my lord. I was searching out for it. This is, I think, akin closest to it.
Give them the citation.
The citation is.
This is Manupatra.
Just a minute.
Yes. He has SCC online open.
I have an SCC citation. Manupatra can analysis. 2021 SCC online, Andhra Pradesh 3964. 3964. On the second last page. I'm very sorry, my lord, this is not paginated properly. Manupatra has this problem.
Paragraph number 21.
21. Sir, meal when apna
If the paragraph tallies at all. What does it start with?
My lord, in view of the same.
Para 21.
21. She will kindly read from the paragraph before it, but that.
But that, yes.
It is, but that it is not intendment of the above said central enactment, as it is clear from the scope and object of the Act. All the types of commercial transaction are saved in the section 21C of the Act, subject to the condition that it satisfied the specified value stipulated under the Act for the purpose of assumption of jurisdiction of the special court, except that no category of commercial transaction is excluded from the purview of the said Act, which is evident from the reading of the above section. In view of the same, as stated supra, the contents of the plaint and the suit documents dated such and such respectively show the transaction reflect building and development of a residential project, namely a pebble beach in an extent of such and such land situated in such and such in the state of Andhra Pradesh in a phased manner comprising in AAA villa and residential apartment, construction of AAA villa in an extent of such and such land, including the subject villa in a gated community project with a further enhancement, customization in the said such and such, setting up of club with its asset and facilities in the common area of the project, availability of water supply for the residents of the project with deep tube wells, connecting with the sewerage treatment plant with latest technology to the entire sewage project, arrangement of solid waste management for its collection and disposal, network of storm water disposal to the entire project, and installation of power supply by providing electricity to common areas like street lights, parks, green verge, community facilities, etc. in the stretch project with 100% diesel generator backup. Therefore, we hold that the above said terms transaction of the said document would reveal that they come under the category of construction and infrastructure contract, and the dispute thereof is a commercial dispute in the meaning of section 21C6 of the Commercial Codes Act 2015, subject to valuation of the suit.
This judgment apparently in paragraph 20 says it can be construction agreements, separately infrastructure agreements, or construction and infrastructure agreements.
Disjunctive and together. And so I rely on the joint venture as well as infrastructure agreement.
6 and 11.
My lord.
And what about the merits?
Oh.
The agreement you have not terminated, you yourself extended, you have applied for sanction which is pending for conversion to residential. How can you stop this signing the lease deeds, lease agreements in a subsisting contract?
My lord, in 2015, the initial contract was entered into in 2011.
Yes.
Was for 4 years. Admittedly, there is no dispute regarding that 4 years has commenced from 2011 itself, because in 2015 they apply for extension of time. When in 2015 they apply for extension of time, I say that I'll impose 1.5 lakhs per month, give a concession, because in contract it says 5 lakhs per month. But it was extended till 2017, and I said that in 2017, if you do not within 2017, if you are unable to complete, I will impose 5 lakhs. So admittedly, the time has expired in 2015 itself. In 2017, he again applies. It was extended till 2021. We start imposing 5 lakhs per month. 2021, he again fails to make the construction, complete it. Says that there are few number of units which was designated as commercial units. He's unable to sell them because there is no demand for commercial units. The authority,
You agree to that?
Authority, Lord, because being a joint venture partner herein, whose name goes with in the advertisement, has something to do in this matter. So we say, yes, we'll help you. It's a bona fide action on our part. We'll write to the Urban Development Department. We are the parastatal under them. So if you may change the nature of user. So
When
that
you write that
in 2022.
with replace that letter.
No, Lord. Is that page 70?
21.
My lord.
February.
My lord, 2nd of February,
2nd of February 2022.
February 2022. And the appellant wrote to the Urban Development Department with a prayer to waive the, my lord, amount we have imposed as delay charges. That was refused. Thereafter, very recently in 2025, they have filed this suit, and this is not a suit for specific performance of contract.
No. What is the suit for?
Suit for recovery of the money they have already paid, and admission that there is a delay. Now they want to recover
You
the
also
amount.
challenge your letter by whereby you have stopped, or your action whereby you have stopped this signing of the
That
lease
was
deed?
done after. That is not the subject matter of the suit.
Suit is only for recovery of that money.
Only recovery of money.
Let us see the prayer.
My lord. Cancellation of that letter has not been sought because that was afterwards.
First prayers are money.
My lord.
Yes. Declaration that no penalty is payable, that is also on that money. And in G, they seek injunction restraining defendant from taking any coercive steps or claiming any amount, or that is also on money.
Money. So how can an order in nature of a permanent mandatory injunction or a specific relief can be granted in such a suit? And the prayer that is being made now before this Honorable High Court is stay of operation of my letter. I say I'll not execute. So there is no operation of it, and they want stay of that.
The letter was written prior to the suit.
Not after the suit was filed.
After the suit.
And initially an injunction application was moved that I'm preventing, so that I may be prevented from taking any steps, coercive step, that was disallowed. And then another injunction application was moved seeking stay on the letter. stay of operation of the letter. That was not taken up for adjudication on that particular day, which brings the appellant before this.
You have passed an order on 16th May. What is that? That the injunction has been sought regarding that.
Not we said that unless you make payments of the delayed amount, will not execute any lease deed. Because a reciprocal obligation is there with the appellant. When there's a clear admission that there is a delay. I understand, my lord, for the purpose of that 2022 February, we had made an application before the UD department. I understand. But till 2022 February, it's an admitted case that they had made default. That also they are not paying. On the contrary, they are asking for refund of it after making payment. So where is the reciprocal obligation being not discharged by the appellant?
But the contract is still subsisting, and your application is still pending. You have applied for change of residence, change from commercial to residential. That application is still pending. What can they do? Unless that is allowed, they cannot carry on the project also.
It is only in respect of a very small portion.
Complete করতে পারবো।
But the later portion, unless they hadn't completed the project, where the buyers came from. There are buyers because they had completed it after the 4 years. So I'm entitled to the delay amount.
No, but see, your logic is circular.
My lord.
In the sense that you are saying, and in the one hand, that you won't be signing agreements, but on the other, if the agreements, the lease deeds are not signed in favor of third parties, they cannot get the money to pay you back. I mean, if your claim is in money, even they have to have that money by selling the property.
My lord, there is a clear clause
This is
in
the
the
dog in the manger policy. What is that clause?
there is a clear clause that even if they are unable to sell, they'll have to pay us our dues.
Yes, but you have no lien or charge over the property for that, or over the contract for that. Now, it's a different money claim. You can always realize the money by doing whatever, but you cannot charge the contract for that and blackmail them by saying I won't execute the. Even if you have a money claim, you have to separately file a suit or counter claim. You recover your money, but for that you cannot withhold the execution of the agreements. That would be counterproductive. That would not fetch them money, and they also cannot pay you, in fact.
But had it been a contract,
Stalling your own project does not mean anything. You're stalling your own project by refusing to sign the agreements.
But had it been a suit for specific performance, he ought to have shown that there is a reciprocal obligation that has been discharged by him. He has not filed it. In the disguise of a money suit, my lord, he's actually claiming specific performance.
There is no prayer in the suit regarding the main specific performance or something.
No.
Only confined to that refund of that period.
So if he takes out a money suit as of now, this is my defense there.
They've claimed for specific amount of money. That those are money. This is a money suit also.
My lord. But in the guise of a money suit, he cannot claim specific performance when he has not discharged his part of the contract.
Very well. So you say they have to pay the money to have you execute the lease deeds. Money at the rate of 5 lakh per month.
My lord.
But
And even
that is the dispute pending also. They have also challenged that you cannot give effect to the letter means that you cannot claim money at the rate of 5 lakh.
My lord. That is there.
So that is sub judice in the suit.
Let the suit be decided, but where the claim for specific performance comes in this suit.
Specific performance they are not claiming. Where do they?
In the guise of this prayer,
What is
actually,
the specific performance they are claiming?
they are claiming that
Execution of the lease.
execution. What is the intention? The intention is execution of lease deeds without paying my money and also claiming refund from me. When admittedly there is a delay, and I tried to help him by writing to the Urban Development Department. And he knew that will not be successful if he takes out a suit for specific performance.
They are paying 1.5 lakh for this period.
Nothing. They had paid an amount. That is the subject matter of the suit that they have claimed refund.
That was at the rate of what?
1.5. I do not have
So
the
that also they are asking for
refund. They actually want to say that you
because
assess it.
subsequently you have renewed, therefore. All right, good.
I do not have the exact calculations, my lord, but
Need not approximately
My lord.
1.5. They have paid some amount in if at the rate of 1.5
my lord,
for some period, but they're wanting that refund. Good. So this is also
my lord.
any reply, Mr.
I'll go by
Mr.
the
Mittu, you have seen the scope of your suit also.
scope of my suit. At that time, there was no refusal to let me perform the contract. There was no termination. How can I ask for
There's
specific?
no amendment in the plaint also.
No, but then my prayer is there for no coercive action. That is there, and this is the coercive action because at that time I couldn't ask for specific problems. Even today now, they are not terminated the contract. They are not telling me not to perform the contract, but they've simplicity withheld, taking a coercive measure. That is my prayer is for coercive action. So now they have taken a simplicity one step that I will not execute the agreements. So I did not place lordship can also see in page 5, paragraph 4. Page 5, paragraph 4. The plans were revised from time to time. Lastly, it was revised in 2018. So a case for refund, I did not argue that case because the plan was revised in 18 also. So the one building was omitted. That has been done. So well, I have said that today when they have applied for conversion, this project will not be complete. In that letter, Lordship kindly notes, they have admitted that the entire project is completed by me. At page 71, they have admitted that the entire whatever I had to do, I have completed. I've got occupancy certificate. That is in page 71. And 18 was the last revised sanction at page 5. So that's in support of my claim for refund, which your lordship made clear on the first day. I will not go into that aspect, so I did not elaborate on that. So, but so far as now it is simpliciter, this coercive measure has been taken by asking me not to, that I will not execute. So, by specific performance of the entire agreement, I cannot have. I cannot ask for. It will be a specific. I mean, whatever can be asked for.
But you're asking them to sign the lease deeds. Isn't that specific performance?
That's one of the obligations. That's one of the obligations. But then I am to yet complete the project. They have not terminated the contract.
What other obligation you have not
Well,
made any other allegation?
well,
Your suit is for refund of that money. You say they are not entitled to claim any penalty.
That is the core issue.
That is the only issue that all the reliefs also revolve around that.
And no
coercive action on the basis of claim of penalty.
And now page 7, and now their present action is because I am entitled to penalty, I will not sign. So the whole core issue is penalty because if they had, so that's the only reason given for their page 216 or so. Because
so, Mr. Mitru, we were just thinking aloud. Suppose injunction is granted, then also why shouldn't the court ask you to put in some security by way of or make regular payments at whatever rate to cover because granting execution.
May I ask myself, how long will I go on?
Because in the garb of this is virtually you are trying to stall their claim of a money.
No, they will not get the money from that.
Roundabout way, you are asking that they cannot make any money claim in your suit. So it's like challenging a money suit.
No, they can. I mean, they can always make a counterclaim for the money.
It is for that. Not only
declaration that this money is not payable.
You have asked for a refund of the money you have paid to them, and you have asked for an injunction. Declaration that no penalty is payable under clause 9.
That is my case.
And injunction, your suit reliefs.
Yes.
An injunction restraining them from taking any coercive action, demanding or claiming any amount by way of penalty in terms of clause 9. So your refund claim is also virtually relatable to that. That declaration that no penalty is payable.
Whether there's any penalties payable now, that's an issue.
Your declaration, prayer F is the key relief. Prayer F in the suit is
that is the key.
Declaration
Absolutely.
that no penalty is payable. Your refund claim is also on the basis of that, and your injunction claim is also on the basis of that.
Basis arising out of
declaration that no penalty is payable. But once you say no penalty is payable, now therefore it's in the nature of you are trying to interdict a money claim being made by them. So
but I want refund. My present suit is for refund on the basis of the declaration.
So they cannot claim some money from you on whatever ground.
Because well, my case is that sanction has not been obtained, final sanction.
So isn't it the mirror image of challenging a money decree? I mean, in the sense that one has a money claim, you are saying he cannot claim any money on the basis of that. You are trying to have an injunction restraining them from claiming any money on the basis of a particular clause.
So that may be my injunction, interim injunction.
No, that is your declaration is also that they cannot claim penalty as per clause such and such.
Well, that is in aid of my first prayers for refund of
So
money.
what the crux of what you say is that they cannot claim a sum of money on the basis of a particular clause in the contract.
Particular clause the contract.
You cannot claim a sum of money. Isn't that to forestall the claim of money? I mean, in the sense, it's a mirror image of challenging a money award, sort of, or a money.
But yes, if
In a negative way,
if-
you are trying to get what you could not. I mean,
well, if there was a money award or decree in their favor, then it would be certainly. But then, as Lordship knows,
but if I try to thwart a money claim, shouldn't I secure that amount or some amount?
well, that is
You are thwarting a money claim. Your
as of
suit is
now.
for that.
Well, as of thwarting the money claim.
If injunction is granted,
That's
then
only
yes.
if injunction is granted.
That is what we are saying. If
So
injunction is
now-
you put in
Now, I am not asking for an injunction so far as not to make the claim as of now. Lordship is not granting.
But your
So-
suit is only
so-
for that.
So very well. So if their intention is to recover money by this process, so execution of the agreements, the money that comes in would go to them instead. Let me put it let's look at it commercially. After all, this is commercially. So what is the purpose?
So you say they cannot coax you into paying that money by withholding the signature of the
That is the point, because if there was no clause in the
So,
contract,
if I owe you some money, you make a money claim.
and also, Ballard, they, on the one hand, saying that I am liable to pay penalty because the contract is still alive, very much alive.
Hmm.
On the other hand, I cannot work with the project because they have applied for conversion of the land.
But your premise is that the contract is alive.
Yes, it
But
is
still
alive.
you say that the penalty is not payable. But you say that by virtue of subsequently extending the time, so they have.
They have, and they're applying for sanction, and they're getting a sanction plan 2018. And also, but they're applying for conversion. So it will never be complete, the project.
For parting, Mr. Mitra, please show us that penalty clause.
Clause 9, page 29. Page 29, clause 9. The party of the second part shall execute the project within a period of 4 years from the date of receiving necessary sanctions from all concerned authorities. All concerned authorities. One of the concerned authorities is the UD department, from whom conversion and whatever 5% of the project is remaining, that is dependent on the conversion.
And second part shall make all necessary applications for sanction also. Which
Yes.
they have done.
Thus, I have done till 18, the last sanction was obtained. So 4 years from that also, if one looks at it, that is not there. But that's the validity of my money claim, my money claim. Shall execute the project. So I cannot execute the project till there is a decision on the conversion. Or
So it says the party of the second part shall 9
Hmm.
execute the project within a period of 4 years from the date of such and such.
from all concerned authorities.
Date of sanction, yes. The party shall file all necessary applications such and such. So very well. In case of failure on the part of you to comply with the time schedule specified to complete the project, and you say still sanction is pending because they have
So they have applied. So it will never be completed. So I shall go on paying forever. At the most, whatever money comes in now, that Lordship can make some provision. If some more money comes in, that through execution of the lease deeds, because that will be the direct consequence of the execution. But I cannot go on paying forever because UD may sit over it for the next 10 years. So then this is a catch-22
security
situation.
by way of you can put it in some escrow account also, suppose. We are just thinking aloud. We have not decided
Yes, well,
whether
of course.
the preliminary objection also has it. So if it's commercial, then we have two options: either to direct return of the plaintiff and presentation before the appropriate court, or transfer would be difficult. Sitting from here to a different court may be difficult.
I have
Practically,
got a judgment. I can show of past precedent of transfer.
both ways there are
Both
judgments.
ways. Both ways
have
there
been
are-
done previously.
both have been done. Return of plane and transfer for
And
the
transfer.
practicality of situation. But here, this is a case where, but overall guidance, overall supervision, as the Lordship has seen, no say in the marketing, no say in the sales, no.
The marketing, yes, you had
No.
to approve the
Lordship kindly, only the contents, the contents. Lordship kindly come.
Please come to 14 and 15.
Page
31.
Page 31.
31.
Page 31. Clause 14.
14 is
The
overall
part
supervision.
overall supervision.
15 is informed.
Overall supervision does not leave it entirely to you.
Overall supervision, yes. The party of the hand 15 will keep the participants informed about the guiding, informed, not a say. And apropos this, Lordship has seen clause 12. It's my sole discretion prerogative. And clause 27, that I have complete liberty to appoint engineers, contractors, laborers. Clause 27. So those are absolutely at my discretion. Overall guidance, overall supervision. And yes, he rightly showed clause that the contents of the advertisement will have to be approved. That is clause 10. But
Yes.
contents, prior approval of the contents.
No,
Of that.
marketing also. Marketing of the first part as their 10 public partner. The party of the second part shall be authorized to use the name of the party of the first part.
So
You are using the name as your public partner towards marketing of the residential infrastructure development. So they are an integral part of the marketing. You are using their name only.
For
It's the Adda project which is going to the public.
it is Adda Sugam Adda project, Sugam Adda project. So that, but at the same time, there's clause 12 and clause 11 and 12.
25, where we are responsible.
And also, well, we are responsible for defective construction. We are liable to them for defective construction, clause 25. And clause 25, 26, 27. Yes, advertisement that I've said, yes, I am also using their name. But that will that make them a job? Maybe a partner in a license to use their goodwill, a license to use their trademark. This is in law, it's a license to use their trademark. Does not make a partnership. The joint venture.
Thank you. We'll just close arguments on that. We'll reserve that.
Well, not only one thing.
Well, my junior rightly pointing out, but that is not necessary. She's been saying they have not suffered damages for the liquidated damages they have claimed. Well, that is too very, very well settled. So that is, I don't think I need to.
They're not saying that. They're not arguing that also.
No, so the penalty, not as a matter of right, but that Lordship has yourself said that they have to recover the damages by due process, whatever their claim is.
Yes.
But the 2022 letter that has been talked about,
Yes.
it's only in respect of 5% of the project.
Yes, 5%. So I can't complete.
So it's
That's what
not
I'm
that
I
4
agree.
years will begin from
No,
2022.
but the penalty, their liability to pay the penalty arises only when the entire project is complete, including even if
Yes.
0.5%. Unless that is completed, the project is not completed. And if
But
that
not-
is not so, you are entitled to penalty. Your entitlement to penalty does not come even. If you say 5% only, then say that they have substantially completed the project.
Otherwise, they have said in the paragraph 3,
No, they have to.
it's entirely complete. they have said.
Completion means entirely completed.
From
So-
2015, it is admittedly that they didn't complete. 2017, admittedly
Totally
they
agree.
complete. And
Totally agree.
2022, my lord, 2022 there may be an arguable case.
Maybe.
But till 2022, there it's admittedly.
Substantial questions having been involved, being involved, the appeal is admitted and shall be heard. Push up. Since the questions involved at the admission stage are similar to those involved in the hearing of the main appeal, we take up the appeal itself for hearing. Push up at the outset, an issue as to maintainability is raised by learned counsel for the respondent to the effect that, according to the respondents, the suit from which the present appeal arises is a commercial suit within the contemplation of the Commercial Courts Act 2015, and the learned trial judge did not have jurisdiction to entertain the suit at all. Full stop. Next para. Learned senior counsel appearing for the appellants addresses the issue of maintainability as well as argues on the merits of the appeal comma, which are controverted by learned counsel for the respondent, full stop. Hearing is concluded and judgment is reserved in the matter.
Deeply obliged.
We have referred to that maintainability point also, so that it's clear that that is also taken and kept.
দিচ্ছে।
এখন এবার থেকে আমি একটা জিনিস করছি, যে বই যে এইগুলো যাচ্ছে তো রিজার্ভ, এবার আমি যখন বাড়ি নিয়ে যাচ্ছি, এবার কি বই লাগছে তাতে সেটা বোঝা যাচ্ছে না। আমি এখনই বলে দিচ্ছি, আপনি একটা সঙ্গে নোট পাঠিয়ে দেবেন, এই কমার্শিয়াল কোর্স অ্যাক্টটা লাগবে, এটা মানে একটা প্ল্যাট করে দেবেন, যেখানে আমি
My lord, I owe an answer to your lordship's query. My lord, readiness and willingness. My lord, this was a suit for specific performance, my lord, of an agreement.
we are not we are willing but not ready. I mean, just remind us. Yes,
My lord,
this is 5.
yes, my lord, suit for specific performance of an agreement for sale of an immovable
You are
property.
challenging refusal of injunction. You filed the suit for specific performance.
Yes.
Yes, just
Yes.
give the main points. We'll just catch up.
Yes, my lord. Suit for specific performance of an agreement for sale of an immovable property.
Right.
My lord, the agreement necessarily suggests that, my lord, at the time of execution and registration of the sale deed, I say, my lord, it suggests, not written in clear words, at the time of execution and registration of the deed of conveyance, my lord, the money is to be paid. In the meantime, my lord, on their instance, my lord, I paid certain amount of money. 10 lakh, my lord, I paid. Then, my lord, they refunded us, my lord, 5 lakh. Out of 10 lakh that, my lord, I paid, 5 lakh were refunded. That was again repaid. But, my lord, this refund showed, my lord, their unwillingness, my lord, to proceed with the contract. So, my lord, we filed a specific performance suit. In the meantime, my lord, there were messages exchanged, which are also, my lord, annexed here, which show that, my lord, they started demanding more money, more than what was, my lord, indicated in the agreement. So, my lord, that was also, my lord, indication.
It was a stamped or registered agreement?
No.
No.
No. My lord, that was also an indication to show that, my lord, they are not adhering to the specific terms of the contract, nor are they willing, my lord, to adhere to the specific terms of the contract. My lord, we filed suit, moved, my lord, ex parte identity. My lord, we did not get that, preferred an appeal. My lord, initially the matter, this appeal was taken up by, my lord, the Honorable Division Bench, presided over by my lord Justice Showmanship. There is a direction, my lord, to put in, my lord, certain amount of money, my lord, within a particular time. My lord, we were not in a position, my lord, to put in the money, took out, my lord, a 3-page application, seeking, my lord, extension of time. My lord, showing that, my lord, it came to my lord's mind, my lord, then where is, my lord, my willingness, my lord, one can understand. Readiness, my lord, where is the readiness to show that, my lord, I'm ready with the money all through the contract, all through the, my lord, tenure of the contract. Now, my lord, I have, my lord, made a little research on this. My lord, 16C, my lord, is possibly, my lord, readiness and willingness. My lord, readiness, my lord, must be, my lord, readiness to perform as the contract, my lord, requires me to perform. If the contract does not require me, my lord, to put in money today, my lord, I need not necessarily show that, my lord, I have command over physical money during the entire tenure of the contract, unless the time comes for me to show the money.
So the contract says that you have to pay the money at the time of registration.
It suggests so. My lord, I will take your lordships to the contract. It
So
does not. Yes. Can you turn to page 24?
This was ad interim or
Yes, ex parte.
ex parte ad interim at the trial
Recusal.
court.
Yes.
The appeal was disposed.
This is the appeal, my lord.
Oh, sorry.
This is the appeal. And my lord, there is one more thing before I show, my lord, the relevant terms of the contract.
Yes.
There is a tenant, Lawrence and Mio. My lord, the contract says that, my lord, he will hand over, my lord, my learned senior friend's client will hand over cash, clear, vacant possession of the property after, my lord, taking necessary steps for his eviction. And then, my lord, the deed, my lord, will be executed. Now, my lord, Lawrence and Mio is still there, and my lord, so far as my knowledge goes, possibly subject to correction, they are still, my lord, receiving rent. So, my lord, time for me, my lord, has not ripened yet, my lord, even to show the money.
Show us that
Yes.
provision also.
Kindly, my lord, turn to page 24. Kindly take, my lord, clause 9.
This term sheet is the contract.
Yes, my lord.
Right.
My lord, I have claimed specific performance of this contract. This is, my lord, dated 30th April 2025. My lords will kindly get the date at the top, my lord, on the right hand side. Then, my lord, clause 9. My lord, total consideration is 7 crore 50 lakh. Then kindly see, my lord, vendors representation and assurances. The vendors have represented themselves as the present co-owners and they are seized and possessed of or otherwise well and sufficiently entitled to the aforesaid premises, and they are enjoying absolute right, title and interest free from all sorts of encumbrances, charges, liens, lease pendants, claims, hindrances, attachments, dates, dues, acquisition, requisitions whatsoever without any disturbance or obstruction whatever from any person whomsoever from any corner, manner, 7 except the lease with Lawrence and Mayo for the ground floor of the said premises. Then, my lord, kindly take clause 13. Termination, the heading is termination of Lawrence and Mayo. Simultaneously with the execution of this term sheet, the vendors have issued a termination notice to Lawrence Mayo, who are presently operating their store from the ground floor of premises as per lease agreement dated such and such. Vendors to assist the purchaser in a swift and effective termination of Lawrence and Mayo within 6 months from the execution of this term sheet.
Vendor to assist purchaser.
Correct.
You have to take steps.
Correct. I mean, they have issued the notice, so I cannot take step. They have to sue. And I'm yet to become owner or the landlord, so I cannot sue for eviction.
No. Right.
Then, property tax dues need not take the trouble. 15. Vendors will hand over clear, cash, and vacant possession of the premises simultaneously upon execution of conveyance sale deed within 6 months from the execution of this term sheet. Definitive documents by the parties, that's not required. Handover of original title documents, may skip it over. Then, comes a negative covenant at page 25. This term sheet is valid and binding upon the vendors and the purchaser as a contract and will come to an end upon execution of the deed of conveyance in favor of the purchaser. So, nobody can terminate this. Vendors herein shall not enter into any contract, agreement, MOU with any third party during pendency of this term sheet. So, there is a negative covenant. It says this will remain valid. And then, we pay money. Though, the contract did not require that, but, we paid money at pages 26 and 27. 5 lakh and 5 lakh. 10 lakh, we paid. And, page 28 is, the document to show that, in the interregnum, I also proceeded, to, engage surveyor and, to do, basic fundamental works.
So,
Then,
other readiness obligation.
Yes. And then, they refunded us, money, which, we have again, repaid to them. Those are there at pages 40 and 41.
So, the only provision regarding consideration is clause 9. Total consideration is full and final price.
Yes.
There is a price.
Yes.
But no clause to show that.
That I have to make any advance payment or anything like that.
So therefore, you say since they have not.
It is simultaneous, reciprocal obligations to be performed simultaneously.
Regarding vacating and handing over khas possession, unless they can.
Along with the execution of the deed of conveyance, because they say so,
unless they hand over khas possession.
And execute and register a deed of conveyance, time does not come, for me to make the payment. Kindly see.
Where is that?
Yes, will kindly have a look at page 15.
No, this.
Simultaneously upon execution of conveyance and sale.
15.
Yes, 15 at page 24.
Yes.
They have to vacate, hand over the vacant position along with execution and registration.
Simultaneous.
So, this is simultaneous reciprocal obligation from my end to pay, from their end, to do two things: hand over position and execute and register sale deed. So, this is what the contract requires us to do. Now, willingness is there. There is no difficulty with regard to that. Readiness. Kindly, have a look at section 16 once. Have gone through this, a trillion times, only to trouble your lordship.
Not so 16C, yes.
16C. My lord, justice, but may I place 16?
Yes. Now you need not aver in the plaint. Previously, you had to aver in the plaint.
That I have averred.
Now you need not.
Oh, well, yes.
Now you need not.
Yes. Specific performance of a contract cannot be enforced in favor of a person, skipping over A and B, who fails to prove that he has performed or has always been ready and willing to perform the essential terms of contract, which are to be performed by him, other than terms of performance of which, this is also important, other than performance terms of the performance of which has been prevented or waived by the defendant. So, what I need to show is my readiness and willingness to perform the essential terms of the contract. Number one.
Consideration is essential term. There cannot be any doubt on that.
At the time of execution.
No, but always been ready to.
Yes,
ready
I will
perform.
Always, I should be always ready.
But in other agreements also, I mean, in any agreement for sale, you have to pay the entire money along with the registration, obviously.
Correct.
In some agreements, there is a provision for advance. In your agreement, there is none.
There's no provision for
But
it.
you have put in some money. We are not on that.
Yes.
But then in every agreement, final payment is done at the time of registration only. Then
Yes.
what is the meaning? Some meaning has to be lent to this. Always been ready and willing.
That has been explained in
So
several.
today, if he wants to execute, you can rely on that clause 15. That handing over possession simultaneously has to be there. Unless he's in a position to show that, then there is no question of.
There is a second part of section 16C also, which says, other than the terms, the performance of which has been prevented by the defendant. Here is a
You have not been prevented from paying the money or getting ready with the money.
my
not freeze your bank account.
No.
My obligation. Not did you waive.
Waiver is on them. With them. I tell your lordship, why? My obligation to put in the money would have come, had they been in a position, to sell and execute and register the deed of conveyance and make over to me vacant possession of the property. They have not done so. On the contrary, so far as our knowledge goes, he is still, receiving rent, which shows, their unwillingness to perform, which is a prohibitive action.
You did that in your plate. Regarding they're still taking payments?
Oh, we have simply said that, they have not shown any, inclination to. Yes, sir. After, the termination notice, there is no suit instituted, nothing has happened. At least, to our knowledge. একবার environment প্লেনটা দেখিস। And number two, the moment they refunded the money, part of it, that showed they are
refusal. That is refusal.
Yes. So that is also prevention. Environment দেখ। But there is something against me also. Explanation I. For the purposes of clause C, where a contract involves the payment of money, it is not essential for the plaintiff to actually tender to the defendant or to deposit in any court any money, except when so directed by the court. Today, there is a direction. Which is why, we have taken out an application, 3-page application for extension of time. That's, as per court's, direction, not in terms of the agreement. So, my readiness and willingness, to adhere to the directions passed by the Honorable Court. Not, my readiness to perform the terms, essential terms of the contract. There is a slight difference between these two. Law is subject to, of course, correction by your
law. Citing judgments on this.
If you,
We'll continue after recess with the judgments. Mr. Kaur will continue after this.
Yes, I have a prior commitment at 2:30.
Your learned friend will continue.
Very well.
The judgments only now. Then Mr. Kaur will argue.
Very well.
By that matter will be over and will come.
Grateful.
Yes, please. Right to judgments.
Yes. The first decision which I'll cite is AIR 1962, Supreme Court, page 77. 77, 1962. This is on the proposition that if the defendant repudiates the contract, then the tender of money is not at all necessary. I say here repudiation is by reason of the action on their part in refunding the money, in not taking step to evict the
Mr. Banerjee, repudiation is the premise of filing of a suit for specific performance. Unless they repudiate the contract, then there is no cause of action for filing a specific performance suit. Then in no specific performance suit, you have to show readiness. Unless somebody refuses to perform a contract,
I followed.
There is no cause of action for filing a
There may be two kinds of situations. One is repudiation, and the other one is not showing any willingness to perform. This is on that proposition. Then I am not troubling your lordship.
No,
this,
trouble.
Very.
The Supreme Court, please do trouble.
Very well. I say here, the repudiation is by reason of their refunding the money, and also by reason of not taking any step whatsoever.
Yes.
Yes, the entire decision is on that. Kindly take paragraph 3 onwards. On June 10, 1943, respondent circuit a copy then. On June 10, 1943, respondent number 1 filed a suit for specific performance and in the alternative for redemption on the footing that the transaction was in reality a mortgage. The trial court dismissed the suit, holding that the transaction on the basis of which the suit was brought was not a mortgage but was out and out sale with an agreement for repurchase, and as the vendor had not paid the money punctually according to the terms of the contract, the right to repurchase was lost and could not be specifically enforced, and the court had no power to afford any relief against forfeiture of this breach. The plaintiff respondent took an appeal to the High Court, and it was there held that the failure on the part of the respondents to actually tender the amount of the consideration does not bar a suit for specific performance, because after the repudiation of the contract by the appellant, the tender would have been a useless formality. The appeal was therefore allowed and the suit for specific performance decreed. It is against this judgment that has come in appeal to this court. The correspondence which has been proved in this case shows that when the respondent solicitor called upon the appellant to reconvey the property in dispute to the respondent and also sent a draft conveyance, the appellant denied that there was any concluded or valid agreement. This was a complete repudiation of the contract to reconvey which the appellant had agreed to by clause 3 of the agreement, which has set out above. As the appellant had repudiated the contract and had thus failed to carry out his part of the contract, it was open to the respondent to sue for its enforcement. But it was argued on behalf of the appellant that the respondent did not tender the price, nor was he in a position to do so. And in that view of the matter, the respondent is not entitled to get a degree for specific performance. In case of these cases of this kind, no question of formal tender of the amount to be paid arises, and the question to be decided is not whether any money was within the power of the respondent, but whether the appellant definitely and unequivocally refused to carry out his part of the contract and intimated that money will be refused if tendered. The principle laid down in such and such is applicable to this case. In that case, may I skip over that? May I read out the proposition. The practice of the courts is not to require a party to make a formal tender, wherefrom the facts stated in the bill or from the evidence it appears that the tender would have been a mere form and that the party to whom it was made would have refused to accept the money. Here, they had already returned once. Lord such and such in such and such accepted the statement of the law and observed. Their lordships think that there is a true and accurate expression of the law, and the question therefore is whether the answer that was sent on behalf of the mortgage amount to a clear refusal to accept the money. This principle applies to the facts of the present case also, and the question is whether the answer sent on behalf of the appellant amounted to an unequivocal refusal to carry out its part of the contract, which in our opinion it was. It was next contended that the offer made by the solicitor is not a proper offer in law, and therefore when the solicitor for the respondent called upon the appellant to execute, they were not bound to do so. We are unable to accept, etc., etc., and that it is the decree is upheld. So here, in the reported decision, there was a refusal by words of mouth, and here, there is a refusal by action. So in case, my lord, there is a refusal to perform their part of the contract, my lord, that amounts to a repudiation. And if there is a repudiation, my lord, I am under no obligation, my lord, to tender money or to show the color of money. Then, my lord, the next decision is, my lord, reported at AIR 1983, my lord, Allahabad 343. My lord, this is on the proposition that, my lord, this readiness should be in accordance with the essential terms of the contract. Sir, my lord, paragraphs 1 to 3, and then, my lord, 5 and 8. My lord, 1 to 3, my lord, will indicate the facts. The appeal is directed against judgment and order, etc., dismissing plaintiff's suit for specific performance. The plaintiff, my lord, may skip over 2 and 3. My lord, these are on facts. Kindly take then, my lord, 5. Before considering the legal questions and the authorities cited by the parties' counsel, I considered it necessary to refer to the agreement executed by the defendants to ascertain the true nature of the terms of the agreement. Under clause 1 of the agreement, the defendants agreed to execute the sale deed within 1 year from the date of execution of the agreement and to put the plaintiff into possession by helping him in laying down foundation and by getting the sale deed registered after obtaining the remaining amount of the sale consideration. It further stipulated that before the registration of the sale deed, the defendants required money, then the plaintiff will pay the same to them, and the amounts of paid shall be adjusted towards the sale consideration at the time of registration. Thereafter, clause 1 contained the relevant condition which has been subject matter of controversy. It reads as under, Farid Doam, etc., such and such, अंडर 1 माह के अदा करेंगे जो जरूरी व लाजमी होगा, which is translated in the preceding paragraph. The above condition stipulated that the second party, the plaintiff, shall pay a sum of rupees 3,400 to the first party, that is the defendants, within 1 month of the agreement, and this would be necessary and compulsory. Clause 2 of the agreement contained the usual term and condition that if the defendants fail to execute the sale deed within stipulated period, it will be open to the plaintiff to get the same executed through court. On a careful scrutiny of the terms of the agreement as contained in clause 1, it is apparent that the plaintiff agreed to pay 3,400 to the defendants within 1 month. The words used in the agreement leave no room for any doubt that this condition was mandatory. The payment of 3,400 to the defendants was not dependent upon the delivery of possession of the plaintiff. The question as to whether the plaintiff was ready and willing to pay 3,400 to the defendants in accordance with the agreement needs consideration. In the plaintiff had pleaded that according to the terms of the agreement entered into between the parties, the defendants were required to put in the plaintiff in possession within 1 month of the agreement by helping him in getting foundation laid. In view of the terms, the plaintiff requested the defendant to accept 3,400 rupees and to put him into possession over the property, but the defendants failed to do so. The plaintiff had all along been ready and willing to pay the money and to get the sale deed executed in accordance with the terms of the contract. Before filing the suit, the plaintiff served a notice on such and such date on the defendants, calling upon them to execute the sale deed after receiving the sale consideration. In that notice, also the plaintiff referred to the terms of the agreement and stated that the defendants had undertaken to put the plaintiff into possession within 1 month and the plaintiff would thereafter pay 3,400 rupees to them. But the defendant failed to comply with the terms of the agreement. The case as set out in the plaint and the notice show that the plaintiff has been insisting to pay 3,400 rupees only after he was put into possession. If there is any doubt, the same was clarified by the plaintiff in the witness box. In his statement before the trial court, Rahat Jan plaintiff stated in his Rahat Jan plaintiff stated in his examination in chief that he was and has all along been ready and willing to get the sale deed executed and to pay the sale consideration. In his cross-examination, however, he stated in unmistakable terms that he was not ready to pay to the defendants unless they put him in possession and helped him in getting such and such. As discussed earlier, the agreement did not contain any condition that the defendant shall put the plaintiff in possession over the property in dispute within 1 month. Under the terms of the agreement, the plaintiff was required to pay to the defendants within a month. Its payment was not linked with delivery of possession of the property. The plaintiff did not pay rupees such and such, as he had all along been insisting that the money would be paid to the defendants only after they had put him in possession over the property. The stand taken by the plaintiff was certainly inconsistent with the terms and conditions of the agreement. There is thus no escape from the conclusion that the plaintiff was not ready and willing. Section 16A of the Specific Relief Act contains a mandatory provision according to which no release for specific performance of the contract can be enforced in favor of a person who fails to aver and prove that he has always been ready and willing to perform the essential terms of the contract which are to be performed by him. Explanation to this section further lays down that the plaintiff should aver and prove his readiness, willingness. Readiness and willingness to perform his part of the contract is to be judged on the true construction of the agreement. The plaintiff's readiness and willingness must be in accordance with the terms of the agreement. The plaintiff cannot add any additional condition for the performance of his part of the contract. The readiness and willingness of the plaintiff to perform the contract should therefore be in accordance with the terms contained in the agreement. The readiness of the plaintiff must be in relation to the real agreement between the parties. If it transpires that the real agreement is not what the plaintiff alleges and the readiness and willingness which the plaintiff displayed was not in relation to the agreement, the plaintiff would be within the mischief of doctrine of readiness and willingness. And then, Millard, in this case, specific performance was not allowed because, Millard, willingness was not in accordance with the terms of the contract. In our case, Millard, the readiness comes, Millard, the question of my being ready with the money would, Millard, come when they are ready, Millard. Firstly, Millard, the Lawrence and Mew is evicted. Clear, Millard, vacant position is, Millard, able to be, Millard, made over to me, and deed of conveyance is executed and registered. Millard, on the same proposition, Millard, there is a Bombay High Court decision of 1989. Millard, this Allahabad was a single judge's decision. AIN 1989, Bombay, Millard, page 170. This is, Millard, a division bench judgment. Paragraphs, Millard, 11 to 18.
Don't multiply too many judgments on the
Wait. Then, Millard, there is a Madras court decision.
No, don't put any. Don't cite any other High Court judgment.
Wait.
On the same point, we won't permit you to multiply. Sorry. Cite your best judgment and get it.
Wait.
Same proposition, not so many High Court judgments.
Millard, only a Calcutta, Millard, judgment decision
definitely.
And one Supreme Court. Millard, on the proposition, then, Millard, when obligations are, Millard, to be performed in a certain sequence, Millard, those are to be performed in that sequence only.
That is more apt to the sequence.
Yes, Millard.
Not your Allahabad judgment.
Millard, AI 1962, Calcutta 103.
You don't have any post 63 Act judgment.
Right, one is there, Millard, Supreme Court 1970 is there.
Language of section 16(6)(c) is very specific, always.
Millard, kindly come to, Millard, paragraph 19. 19. Millard, the facts and the law, Millard, are pleaded. Then kindly take, Millard, paragraph 24. Apurvodhan Mukherjee, the net advocate for the appellant, contended before us that the conduct evidenced by the plaintiffs did not amount to that the conduct evidenced by the plaintiffs did not amount to readiness and willingness to perform their part of the contract. They prayed for time because they had not the money. They did not take proper steps to complete the transaction even within the extended time. Here was a case, Mr. Mukherjee contended, where delay defeated equity and the plaintiffs were no longer entitled to claim specific performance of the contract of reconveyance. Elaborating his contentions, Mr. Mukherjee, Millard, may skip over that. Kindly then, Millard, kindly take, Millard, paragraph 30. We are not prepared to accept this argument of Mr. Mukherjee for reasons herein after stated. The observation in such and such relied upon by Mr. Mukherjee is not a legal proposition at all. Their lordship treated the tender of the money by the plaintiff in the aforesaid case merely as piece of evidence showing the readiness and willingness on the part of the plaintiff to perform his part of the contract. Their lordships did not lay down as a general proposition of law that payment or tender of the consideration was the only method of exhibiting readiness and willingness. Then again, in such and such, prior tender of the money was made obligatory under the agreement in that case. Their lordship did not lay down a general proposition of law that without such a prior tender, a claim for specific performance can never be sustained. Their lordships also indicated the circumstances under which a plaintiff may be excused from making a tender. The case reported in such and such was decided on its special facts, and the failure to tender was attributable to inability of the plaintiff to perform the contract on the evidence adduced in that case. That case is no authority or proposition contended for Mr. Mukherjee under Section 46 of Contract Act, whereby the contract, a promisor is to performance his promise without application by the promisee and no time for performance is specified under the engagement must be performed within a reasonable time. Under Section 48 of the aforementioned Act, when a promise is to be performed on a certain date and the promisor has not undertaken to perform it without application by the promisee, it is the duty of the promisee to apply for performance at a proper place and within the usual course of hours of business. The law as to performance of reciprocal promises, this is possibly important, however, somewhat different from the manner of performance of promises which are not reciprocal. Under Section 51 of the Contract Act, when a contract consists of reciprocal promises to be simultaneously performed, no promisor need perform his promise unless the promisee is ready and willing to perform his reciprocal promise. Section 52 of the Act, however, provides that where the order in which the reciprocal promises are to be performed is expressly fixed by the contract, they shall be performed in that order, and where the order is not expressly fixed by the contract, they shall be performed in that order which the nature of the transaction requires. Section 55 of the Contract Act is to the following effect. Where a party to a contract promises to do a certain thing at or before a specified time or certain things at or before specified times and fails to do any such thing at or before the specified time, the contract or so much of it as has not been performed becomes voidable at the option of the promisee if the intention of the parties was that time should be of the essence of the contract. If it was not the intention of the parties that time should be of the essence of the contract does not become voidable by the failure to do such thing at or before the specified time, but the promisee is entitled to compensation from the promisor for any loss. The ordinary rule governing vendors' purchases is that the payment of consideration is to be simultaneous with the execution of the deed and shall be made at the time when the conveyance is executed. In any particular case, however, the parties may agree to deviate from the ordinary rule. Unless, therefore, there be a special contract, the parties are to follow the ordinary rule relating to payment by the vendors and the purchasers. Then, my lord, paragraph 40. Since we have already held that under the reciprocal promises expressed the agreement, the plaintiff are not bound to tender or deposit money as a condition precedent, the decision reported is such and such is of not relevant consideration, does not stand in the way of the plaintiff in getting a decree for specific performance.
Mr. Banerjee, if you get a decree today,
Yes, my lord.
till date there is no eviction, will you take the decree or waive it?
My lord, I will take it.
If today a decree is passed, won't you have to pay the consideration?
Yes, my lord.
Can you say that no, you have not evicted, so I'll not pay and not take the fruits of the decree?
That is an obligation, my lord, to be
16 is for that purpose only, 16C.
Yes, my lord.
There is no consideration of 16C in this entire judgment.
The law is, my lord, discussed.
Section 16C is very specific. Very, very specific.
Yes, my lord.
That section has not been considered, and this is not a binding precedent on Section 16C. I'm sorry.
The language of Section 16 is.
So the 1961 judgment, 1960, the provision has not been considered. The previous Specific Performance Act has not been considered. Only Contract Act and general principles.
My lord, if I go by the language of Section 16C, of course, my lord, subject
always.
Yes, always, my lord, essential terms of the contract. My lord, I should be always ready to perform the essential.
Consideration is the essential term, Mr. Banerjee.
And my lord, that is to be paid. My lord, ordinary rule is at the time of execution of the deed of conveyance. My lord, if this promise is
not if you file a suit for specific performance. Sorry, Mr. Banerjee. Ordinary, it is to be paid then if it is ordinarily performed. But if you file a suit for specific performance contract, You have to prove that you are always, that is the language of section 16C. I'm quoting section 16C. You have to always be, if you file a suit, and if you want a decree for specific performance, the plaintiff always has to be ready and willing
This
to perform your part of the
this
contract.
expression always is possibly discussed in a Supreme Court decision. The
Not in
last
the
decision I will
context
cite.
of section 16C. Oh, yes, cite that. Up to now, we have not got anything to deviate from the position of section C. If you file a suit for specific performance, if you are ready to have the fruits of the decree
Yes.
without that eviction, then you have to be ready to pay the money at all points of time during pendency of the suit. That's very clear in section 16C.
I was thinking that essential term was
You cannot have it both ways, Mr. Banerjee.
Yes,
You say you have not given me, very well. They might have not performed their part of the contract. There is no doubt on that.
yes,
But that gives you a right to file a suit for specific performance, and if you get a decree, you will have the deed executed in your favor, with or without that eviction. But the moment you file, this is to show your bona fides as a plaintiff in a suit for specific performance. Because at the end of the day, specific performance is an equitable relief.
Yes,
Court has the discretion to refuse it also, although you prove your case. That discretion is there. Now, therefore, Mr. Banerjee, you have to show your bona fides all along. That today, if you get a decree, you are ready with the money, the consideration amount, the entire one. Because the moment you file a suit for eviction, specific performance, theoretically the next day you should be ready with the money, because the decree, even if the decree is passed, the decree may be passed on any date. So throughout that period, if you want a decree, during the period which you want a decree, you have to be ready with the money.
I was just thinking aloud, throughout the period, the period will commence when? The period would possibly commence when, the situation would arise for me,
The period
to
will
make the
commence
money
when you
ready.
file the suit for specific performance, Mr. Banerjee, because the specific performance suit, it's a requirement in a suit. If you don't file any suit, section 16 is not invoked, not attracted at all. Section 16, when does section 16 come in? Let us revisit section 16
Yes,
once. There is no applicability of
no
section
decree
16.
for specific performance would be
Exactly,
granted.
unless
That
you
is why.
file a suit for specific performance, there is this question of your being ready with the money. You can do whatever, you can sleep tight without the money. No difficulty on that. But once you claim a decree for specific performance, Mr. Banerjee, you have to prove that you have performed or has always been ready and willing to perform the essential terms of the contract. Essential terms of the contract is the essential contract of term which is performable by you.
Yes.
Consideration is one of the essential. Essential terms of the contract does not mean that it's dependent on something else or something like that. Whether that part of the contract is essential term of the contract. Consideration is one of
But
the
I follow.
essential
I
terms.
follow.
Suppose there is an ancillary term
I follow.
that you have to come in a blue shirt and
Yes.
sign that agreement.
Yes.
There may be somebody may fancy that in the agreement, but then that's not an essential part. Or you may have the money from a particular bank, not an essential part. But you have to have the money. Consideration passage is an essential term. The test is, Mr. Banerjee, because today we have to ascertain, the court has to ascertain, today if we pass a decree in your favor, whether you are ready to get that amount or it's a fancy litigation. If it's a fancy litigation, we won't exercise our discretion. So that's why in a suit for specific performance, you have to show that you have to prove that you are always ready and willing to perform.
If today a decree is passed, for specific performance of that contract,
Exactly.
the property should be first vacated, live vacated.
That is where
My lord had asked a question. Yes.
No, is it? If a decree of are you wanting that? Then should the court wait indefinitely till they evict them?
Then there is another
That's a
difficulty.
ridiculous proposition, Mr. Banerjee, you are making. You have filed a suit for specific performance, asking for specific performance today. Can you make it conditional for the court? Can you ask the court, don't pass a decree for specific performance?
Contingent contract.
You are asking for specific performance today, the moment you filed a plaint.
True.
On that date, you are asking, pass a decree for me today. From that date till the decree is passed, if at all, you have to show that you are ready and willing with the money. Because the day you are filing a plaint, you are seeking specific performance from on that date. And throughout the period when the suit is pending. Otherwise, withdraw your suit, wait till they evict, and then come back with a suit. Tell us it is not a ripe suit. You file a suit and you don't comply with 16C, and you come back to the court and argue that no, they had to do this first, that first. They are at fault. Everybody knows that. They have not yet evicted. But it's your suit. And it's you who has to, then would you shy away? That's why that was the first question we asked you. And the only question we asked you. Today, if a decree of a specific performance is passed by the trial court, would you stall that? Would you not take the fruits of that?
I can't.
Not put it into execution
I
till they
can't.
evict? Isn't that an absurd proposition you are making? You have sought for a suit for a specific purpose on the situation as it is today. Today there is no eviction. In the present conditions, you have asked for a specific purpose of an agreement. You are saying in the suit the prayer is give a direction for specific purpose of that agreement.
For sale, yes.
So therefore, as of today, if the court passes a decree, a deed is executed in your favor without the eviction. Then you have to admit simultaneously that yes, the suit is not, the cause of action is not right. You cannot have it both ways. Anyway, cite the judgment.
এটা 70 Supreme Court কি এটা? এটাই, এটাই।
70 71
না 70 টা।
It's like saying I rely on a document and I won't have it impounded. Mr. Banerjee, it's like saying I rely on this document, I won't impound it. Because it's the other side whose duty is to pay their stamp. Go ahead with that. Don't have it impounded. Don't get your suit decreed.
এটা 16C ডিসকাস করছে কিনা একবার দেখি।
Specific performance suit ওর আজকে
ওটা দিয়ে লাভ হবে না।
ওকে ডিউটিটা না নিয়ে বলবে না এভিক্ট করে তারপর নেবো। টেস্ট হচ্ছে ওটাই 16C এর কারণেই রয়েছে যে আজ যদি ডিক্রি হয় ইউ হ্যাভ টু বি রেডি উইথ দ্য মানি, আদারওয়াইজ ইটস আ ফ্যান্সি লিটিগেশন।
এটা বলতে লাভ হবে না।
7 কোটি 5 লাখ টাকা দেওয়ার কথা, 5 লাখ করে দেওয়ার দিয়েছে।
Not only one decision, my lord, yeah, 1970 volume 3 Supreme Court cases, page 140.
50 লাখ দিত, সেটা যদি রিফিউজ করতো তাহলে আমি বুঝতাম। 7 কোটি 50-এর মধ্যে 2 আর 5 লাখ করে দিয়েছে।
78
না আমি 71 টা দেখাচ্ছি। হ্যাঁ
কথা হবে
না না 1970 volume 3.
কাল যদি ডিগ্রি পাস হওয়ার বলবে যে না এভিক্ট করে তারপর দাও।
But possibly, my lord, a different judgment has been handed over in 1970. Right, paragraph 6 of, my lord, this one. My lord, somewhere, my lord, in between, my lord, paragraph 6 starts at, my lord, page 7. Kindly turn to, my lord, page 8. Somewhere, my lord, towards the middle, my lord will get on the right hand side a sentence starting with readiness and willingness cannot be treated as a straitjacket formula. Page 8.
yes.
This readiness and willingness cannot be treated as a straitjacket formula. These have to be determined from the entirety of the facts and circumstances relevant to the intention and conduct of the party concerned. In our judgment, there was nothing to indicate that the appellants at any stage were not ready and willing to perform. The High Court had taken another aspect of readiness and willingness into consideration, namely the possession of sufficient funds by the appellants at the material time for payment of the balance of the sale price. Ramesh Chand, PW6, had stated that his father was a headmaster in a high school. He was also doing import business. He gave up service and joined, etc. The bank account produced. The appellant's father had in account a credit of such and such, but thereafter, between such and such an amount odd had been withdrawn. According to the High Court, after these dates there was nothing to show that the appellants had any fund. The evidence of Ramesh Chand that the family had an amount of rupees such and such lying at the house was not believed. Now, in the first place, the relevant period of determining whether the appellants were in a position to pay the balance of the sale price was after November 1956, when sanction had been obtained by the respondents for transfer of the plot from Rehabilitation Ministry. The appellants had admittedly paid without any difficulty as rupees such and such as earnest money, and the bank account of the father showed various credit debit entries. On March 5, 1956, an amount had been withdrawn by a check. According to his statement, this amount was withdrawn because his father fell ill. It was deposited with his mother, remained with her throughout. There is no material evidence to show that this amount had been spent. That the statement of Ramesh Chand was false on this point. Even if the version that rupees 40,000 in cash were lying at the house is discarded, at least an amount of rupees such and such must have been available at the material relevant time. The appellants were carrying on business. There is nothing to indicate that.
And the facts of the case.
Milord,
They had been
it says relevant time was, Milord, when the no objection was, Milord, obtained from the concerned authority.
it was the municipality which was the other party to the contract.
And there was, Milord, a sanction that is what
obtained.
was required. So after
This agreement, no sanction is to be obtained.
in this agreement, sanction is not required, but
That's not a requirement of law. Here it was a requirement of law. Unless they had a sanction, suppose a decree for specific performance was passed,
Yes.
no deed could be executed because there was no sanction.
No sanction, no objection.
Sanction.
Yes.
In your case, it's a term of the contract that they have to evict that person.
And Milord, that is to precede. But again, Milord,
That is to proceed as per your contract. Yes, definitely.
no. So these are, Milord, my HON'BLE.
Yes, Mr. Paul.
And Milord, negative covenant, Milord, that I have shown to your lordship.
Okay.
That Milord, page 25 of Milord, my application. Milord, there is a negative covenant which say that Milord, they will, Milord, this is Milord, irrespective of anything.
Support of your injunction prayer.
Yes.
Yes.
Yes. This is Milord,
Otherwise, you have a good case.
irrespective of anything, Milord, whether or not Milord I tender money, etc. Milord, this is Milord, they till Milord the contract subsists, they cannot.
Right.
Milord, section 42 of the specific relief act, Milord, for performance of negative covenant.
No. Yes, elaborate on that. Elaborate on that.
Yes,
Mr.
Milord, section 42, kindly just have a look at.
Yes.
Notwithstanding anything contained in clause such and such, where a contract comprises an affirmative agreement to do a certain act coupled with a negative agreement express or implied not to do a certain act, the circumstances that the court is unable to compel specific performance of the affirmative agreement shall not preclude it from granting an injunction to perform the negative agreement, provided that the plaintiff has not failed to perform the contract so far as it is binding on him. There is no failure, Milord, as such on my part.
No, here this is not the section which you want to relay. Your contract itself provides that they cannot do it.
Yes, correct. So, Milord, there is a negative covenant, negative agreement coupled with an affirmative agreement that they will sell. That, Milord, today your lordships cannot, Milord, ask them, Milord, to sell the property. I cannot ask for specific performance of the affirmative part. Does not debar the court, Milord, from enforcing negative part.
Yes, Mr. Court. And your application is pending for extension of time.
Yes, Milord.
What amount was directed to be deposited?
50%. 50%.
Yes.
Milord, that we need, Milord, my client's instruction is, Milord, 3 to 4 weeks.
Yes.
Lord, kindly take the term sheet once. Because, Lord, my case is that the term sheet will show that this is not an agreement. This is, Lord, a broad terms, and there is a specific agreement between the parties to enter into a formal agreement. I'll just show that. First, Lord, premises is mentioned as first. Then, Lord, your lordships will see the land area is mentioned. Then, Lord, existing structure. This is just the description of the property up to this. Total built up area. Then transaction, sale transaction. Then vendors, name of the vendors, purchaser's name, total consideration, 7 crore 50 lakh. Then vendor's representation, that this will be sold free of charges, lease pendants, liens, etc. Indemnity by the vendors. They have assurance that they have a clear marketable title. Then, Lord, the documents for due diligence. Kindly, Lord, mark this. This is purchase deed of Kartik Chandra Datto, mutation certificate, etc., etc. Then, kindly see the last one, lease agreement with Lawrence and Mayo for the ground floor of the premises.
Clause 18 is against you, what you are saying.
No, Lord, please come to clause 16.
Yes.
15 first and then 16.
All right.
16 says, but before that, I would like to, Lord, also read clause, Clause
16th,
13. Kindly, my lord, take clause 13. Simultaneously with the execution of the term sheet, the vendors have issued a termination notice to Messrs. Lawrence and Mayo, who are presently operating their store from the ground floor of the premises as per the lease agreement dated 14 September 2017. Vendors to assist the purchaser in swift and effective termination of Lawrence and Mayo within 6 months from the execution of this term sheet. So, my lord, basically, what they say that they will take the lead. The vendors are to assist them for the purpose of exit of Lawrence and Mayo. Then, my lord, please come to clause 15. Vendors will hand over clear, khas and vacant possession of the premises simultaneously upon execution of conveyance sale deed within 6 months from the execution of this term deed. This term deed's date is 30th April 2005. Then, Lord, 16. Vendors will enter into an MOU with the purchaser subsequently and thereafter will execute the deed of conveyance. So, Lord, it will be in 2 stages. First is a formal agreement where, Lord, the terms and conditions will be formalized because, Lord, here there is no question of payment of any earnest money. Only, Lord, consideration is mentioned. And, Lord, they will make a due diligence with regard to the title search. On title search, there will be an MOU. This is the stages, Lord, at which the agreement is provided. There is no question of making any payment. And, Lord, the transactions to be completed within a period of 6 months, and the validity of the term sheet, that's the clause my learned friend says, that this term sheet is valid and binding upon the vendors and purchasers a contract and will come to an end upon execution of deed of conveyance in favor of the purchaser. Provide deed of conveyance is condition upon entering into an MOU. Now, Lord, today there is no question of making any earnest money payment. My learned friend's case is that suddenly they paid 5 lakhs or 10 lakhs. Now, Lord, where is the question of making payment of 10 lakhs? They could have forwarded a draft agreement of MOU, calling upon the vendors to sign it. Lord, after this, there has been stoic silence. In the suit, there is not a single document disclosed, conveyance, correspondence exchange between the parties, where, Lord, they call upon the vendors that here is the agreement, we are forwarding the agreement, enter into the agreement or sign the agreement. There is not a single document. Only action taken is they send into their account directly 2 checks for 5 lakhs they pay 5 lakhs in cash and 5 lakhs by check. Now, my lord, in the plaint itself, if your lordships, my lord, kindly come to the plaint, kindly take, page 40 and 41, the 2 documents. First, my lord, payment, which is at page 26. Out of all the vendors, they pay one of them. Your lordships will find the cash receipt, page 26. At the top, it is written confidential.
Yes.
They pay 5 lakhs to one of the vendors, Shampadas. There are 3 owners, each having one undivided 1/3 share. So, my lord, payment made to Shampadas, and kindly see the next check. Check also, my lord, paid to Shampadas. Now, Lord, your lordships will find that this payment was returned, page 40 and 41. If your lordships kindly come to.
Yes.
Kindly see 41, that will suffice. The first entry. 24th of July, this 10 lakhs is returned. Lord, the issue was that, Lord, they have not been acting in terms of the agreement. They were supposed to, my lord, do a due diligence on the documents. They were supposed to come back with an MOU, which they did not do. Now, my lord, not stopping here, what happens is that, Lord, they say that they have done some survey. Now, Lord, that survey they were supposed to do in terms of due diligence. The lordships will see clause 12 that they have done. Now, Lord, after that, what happened? When it comes to entering into an agreement, question of payment of earnest money, because, Lord, it's not their case that they are not accepting the title. That is also not their case. It is not their case in the predate that they have done a due diligence and they are not accepting the title. On the contrary, they have filed a suit for specific performance, as fell from my lord. That when they file a suit for specific performance, their readiness and willingness has to be implicit. Apart, this section 16C obviously mandate that they have to be ready with their money. But Lord, when they obtain the interim order, if your lordships now kindly have a look at the order, Lord, that was passed on 9th of September. That must be in the order sheet.
order sheet টা দিন।
Because Lord, that order was also obtained ex parte. At that stage, Lord, we were not served. 9th of September 2025.
Yes, yes.
Kindly see paragraph 16.
Yes.
My learned friend is arguing elaborately that there is no question of willingness because we are not willing to execute the conveyance, or there is not non-willingness. Paragraph 6 of the order, Lord,
Yes.
9th of September.
6, yes.
The plaintiffs willing to deposit 50% of the consideration amount within a week from date would be entitled to an order of injunction restraining the respondents from dealing with alienation or encumbering the suit property unless it has already been encumbered from the date of such deposit. We have been informed that the defendants are already in possession of the suit property. Let the matter appear after fortnight. In the event the plaintiff deposits the amount with the learned Registrar General within the aforesaid period, there shall be an interim order as mentioned above. The factum of deposit shall also be intimated to the respondent. In the event the said amount is deposited with the learned registrar, the said amount should be invested in a suitable fixed deposit. Then, Lord, the rest. The fact remains is that, Lord, after this, they did nothing. Only when the matter came up on the returnable date before your lordships, they came and said that they have taken out an application for the purpose of extension of time. Now, Lord, 8 weeks extension is prayed for in the application. That takes us, Lord, beyond the 6 months period which is agreed to on 30th of April 2025. So, Lord, 6 months has expired on 30th of October 2025. They have shown nothing.
But you have not also done anything for eviction.
Lord, we have issued a notice that is accepted.
That much, but if you issue a notice, you have to file an eviction.
But that they say that we have to facilitate them for the purpose. We will cooperate with them. If your lordship sees the term sheet,
it says that. But what is the sort of cooperation?
Lord, they will prepare the plan.
They cannot file a suit.
They'll prepare the plan, bring it to us for the purpose of getting it signed. These ladies, Lord, have entered into a contract where, Lord, assurance is given to them that everything we'll do, you don't have to do anything. And, Lord, a notice of eviction which was required to be given, they have given that notice of eviction. But what happens after 30th of April? Lord, this payment, I understand, your lordships will see from the receipt, was made sometimes in May 2025. Now, Lord, before payment, they had no obligation to pay. They pay one of the co-owners, and, Lord, they don't give the MOU for signature. The MOU should have contained, Lord, more detailed, Lord, terms and conditions as to how much money they are willing to pay upfront as earnest money, because they have property of 7.5 crores. They can't, Lord, get away with payment 10 lakhs. This is an Lord, this is a suit to only avoid their obligations, Lord, under the term sheet. And, Lord, this is deliberately done so that, Lord, if they go to court, obviously it will continue for years and these ladies will be without any remedy. Your lordships will find the owners are poor ladies. They have been assured that you assist us, we will take all steps. This is how the term sheet is prepared. And, Lord, today the point is taken that we are not acting in terms of the agreement. If your lordship looks at the term sheet, it clearly says that, Lord, they will take the lead role. Vendors to assist the purchaser in swift and effective termination of Lawrence and Mayo. And Lord, a blunt question from the court that are you willing to seek specific performance if Lawrence and Mayo is still continuing? The answer was yes. Either they are willing to go ahead or they are not willing to go ahead. If they are willing to go ahead, they are bound to show their readiness and willingness. And Lord, I would just show Lord the one judgment, Lord, that 1995 volume 5 SCC. If they have filed a suit, they have to, Lord, perforce, Lord, show their readiness and willingness. And here, Lord, the court has given them an opportunity which they have failed to avail of, which clearly shows that they are not ready and willing. Now, Lord, please come to paragraph 5. First, Lord, paragraph 4. Kindly see, Lord, they were asked to deposit 2 lakhs of rupees. Paragraph 4, Lord, will talk about the facts. And then paragraph 5, it is settled law that remedies for specific performance and equitable remedy, as in the discretion of the court, which discretion requires to be exercised according to settled principles of law and not arbitrarily as adumbrated under section 20 of the Specific Relief Act. Under section 20, the court is not bound to grant the relief just because there is a valid agreement for sale. Section 16C of the Act envisages that the plaintiff must plead and prove that he had performed or has always been ready and willing to perform the essential terms of the contract which are to be performed by him, other than those terms and performance of which has been prevented or waived by the defendant. The continuous readiness and willingness on the part of the plaintiff is a condition precedent to grant relief of specific performance. This circumstances is material and relevant and is required to be considered by the court while granting or refusing the grant of relief. If the plaintiff fails either to aver or prove the same, he must fail. To adjudge whether the plaintiff is ready and willing to perform his part of the contract, the court must take into consideration the conduct of the plaintiff prior and subsequent to the filing of the suit, along with other attending circumstances. Now, Lord, not a single averment that, Lord, they had drawn up the MOU and sent to us.
Averment is now not necessary.
Not necessary, or Lord, at least
After
Lord, the
2018
draft MOU. At least the draft MOU that we had sent the draft MOU, they had not. Lord, after all, Lord, it is equitable relief. So, Lord, Lordship will have to balance from both sides whether there is a failure on our part to sign the contract which was provided to us. Because, Lord, merely coming and telling the court that there is a failure will not do. Your conduct has to show. Lord, the other judgment is that what is readiness and willingness? That is, Lord, 2011, Volume 1, SCC 429, which says readiness is financial capacity and, Lord, willingness is conduct of the plaintiff wanting performance. This is, Lord, paragraph 22, if your Lordships kindly look at.
They were directed by the court to pay, put in 50% of the entire consideration.
Entire consideration. 7 crore 50 lakhs, the 50% of that. The words ready and willing imply that the person was prepared to carry out the terms of the contract. The distinction between readiness and willingness is that former refers to financial capacity and the latter to the conduct of the plaintiff wanting performance. Generally, readiness is backed by willingness. And Lord, then paragraph 23, your Lordships will find that an earlier judgment, this 95, that 115, the judgment I cited, that has been quoted. It says continuous readiness and willingness. That is approved. So, Lord, where is the question of continuous readiness and willingness? That when the court gives them a chance to put in the money, they don't.
Yes.
And Lord, I've also got a judgment which says that agreement to enter into an agreement is not an enforceable that is, my lord, 2009. And my lord, paragraph 25 of that judgment may also be taken note of, that section 16C is discussed. That
Yes.
2011. Lord, 2009, a judgment of 2009, volume 1, SCC 475. আমার কাছে একটা আছে দেবো কি কম আছে জাজমেন্ট কম আছে হ্যাঁ এই paragraph 22 may kindly be taken note of. '21 and 22. In this case, Lord, there was a share purchase agreement.
Para 22, yes.
Par 22.
That is settled, but since you're ready with the judgment.
But the term sheet, if your lordship looks at the term sheet, your lordship will find that it describes the property, the owners, every description is there, and then broadly decides that they will do a search of the title deeds, and with a eviction notice will be issued. That will be, these are all broad terms. But Lord, there was also an agreement to enter into a formal agreement, MOU. That really would have given the terms and conditions on which, Lord, the ultimate conveyance has to be executed. But the last point is that, Lord, they are seeking enforcement of the term sheet, where, Lord, no stamp is put. This is on a plain piece of document. And a transaction of 7.5 crores in respect of an immovable property. So, Lord, this is a clear case, Lord, where the appeal should not be entertained, because they are not in a position, Lord, to adhere to any of the terms and conditions. These are my suggestions.
Yes, Mr. Banerjee.
Okay.
Short reply.
Yes.
Stamp, particularly stamp and MOU.
Milord, stamp, Milord, this is not the time, Milord, to enter into that question, because, Milord, the full bench decision of the Honorable Supreme Court says, Milord, when it is tendered in evidence, then only, Milord, the
MOU?
question would be gone into.
Agreement to
Milord,
enter into-
MOU, Milord, it does not say that, Milord, we have to tender, Milord, an MOU to them for them, Milord, to sign. Milord, it is not a case, Milord, made out by them also.
Our court's point is not that. He says this is an agreement to enter into an agreement,
Milord,
which is not enforceable in law. That is settled.
yes, Milord, agreement to enter into an agreement means that, Milord, in the upcoming agreement, Milord, there may be certain terms, Milord, which would be contrary to this and that.
Clause
Here,
16.
Milord, this is just a formality.
Clause 16.
Yes, Milord, clause 16 says, Milord, this agreement would be followed by an MOU and the deed of conveyance would be
And
in accordance with
thereafter,
the terms of MOU. Correct.
no, and thereafter we'll execute the deed of conveyance.
Yes,
As per
the terms of the MOU.
Mr. Banerjee, vendors will enter into an MOU with the purchaser subsequently, and thereafter will execute the deed of conveyance as per terms of the MOU.
Yes.
Not this. So what is your answer to this?
Milord, it was, Milord, for them first, Milord, to prepare, Milord, the MOU.
Whatever.
Yes.
Unless there's an MOU, whether this is itself an agreement to enter into an agreement which cannot be enforced.
Milord, the agreement, Milord, the essential terms of the contract are all enumerated here. Which property is to be sold, Milord, at what price the property is to be sold, within what time, Milord, the property is to be sold. Those are all there. Milord, MOU was, Milord, just a formality. It was not, Milord, a substantive agreement which could have, Milord, deviated from, Milord, the term sheet.
Very well. We've heard it.
Great.
At order. The present appeal involves questions of fact and law and as such admitted, full stop. The issues involved in the in the hearing of in the main appeal and the admission stage being identical, comma, we take up the appeal itself for hearing. Full stop. Next para, learned counsel appearing. Mr. Banerjee, take your seat. Learned counsel appearing for the sorry. The present appeal arises out of the refusal to grant ad interim injunction in favor of the plaintiff stroke appellant in a suit for specific performance of a purported agreement comprised in a term TRM sheet within single inverted dated April 30, 2025, whereby allegedly the parties entered into a contract for sale of the suit property. For sub next para, the learned trial judge, comma, in the impugned order, comma, despite having come to the conclusion that a prima facie case had been made out, comma, refused to grant injunction since apparently no urgency had been made out. For sub next para, learned counsel for the appellant argues that although at a previous stage of the present appeal, comma, the appellant had expressed its willingness to deposit 50% of the entire consideration amount of rupees 7 crore 50 lakh, comma, an application has been filed subsequently for extension of such time due to unavoidable circumstances on the part of the appellant. Full stop. Next para, it is argued further that there was no scope for the court to insist upon readiness and willingness in the form of deposit of any sum of money in the present case in view of the circumstances of the case and the terms of the agreement itself. Full stop. Next para, learned counsel takes the court through certain clauses of the agreement, comma, in particular clause 13 and 15, clauses 13 and 15, which conjointly provide that simultaneously with the execution of the term sheet, comma, the vendors had issued a termination notice to a tenant in the property in question, and the vendors were to assist the purchaser in a swift and effective termination of Lawrence and Mayo within 6 months from the execution of the term sheet. Next para, clause 15 provides that the vendors within bracket respondents would hand over clear, comma, খাস and vacant possession of the premise, খাস হচ্ছে KHAS, খাস vacant possession of the premises simultaneously upon execution of conveyance stroke sale deed within 6 months from execution of the term sheet. Next para, learned counsel submits that since till date no steps for eviction of the said tenant of the suit property and handing over the vacant possession of the same to the appellant has been taken by the respondents, comma, there arose no occasion for payment of the consideration amount which was supposed to be simultaneous with the execution and registration of the deed of conveyance. For some next para, as such, comma, learned counsel for the appellant argues that the question of readiness and willingness does not arise in the present circumstances, comma, since even as per the terms of the agreement, comma, the time has not come for the consideration amount to be paid by the appellant. For some next para, it is mentioned in the passing that twice, comma, quanta of rupees 5 lakh on each occasion were tendered to the respondent by the appellant. However, comma, by returning the said amount, comma, the respondents have lost the right to plead that the appellant is not ready or willing to perform its part of the contract. Next para, learned counsel for the appellant places reliance on such and such reported at 1961, sorry, AIR 1962 Cal 103. Next para, in the said judgment, comma, the Honorable Supreme, the division bench, our division bench of this court, comma, while considering several facets of the Contract Act, came to the conclusion that the ordinary rule governing vendors and purchasers is that the payment of the consideration is to be simultaneous with the execution of the deed and shall be made at the time when the conveyance is executed by the vendor. Push up. The division bench dwelt DWELT on reciprocal promises and the consequences thereof, and observed that a previous division bench, in a judgment reported at AIR 1928 PC 174, did not lay down as a general proposition of law that payment or tender of the consideration was the only method of exhibiting readiness and willingness. Full stop. In the case under consideration, the division bench observed that the prior tender of money was made obligatory under the agreement in that case and cannot be a blanket proposition in every possible suit for specific performance. Push up next para. Learned counsel next cites such and such reported at AIR 1962 SC 77, where the Honorable Supreme Court observed, inter alia, that in cases of the kind as dealt with by the court therein, where the consideration amount had been tendered but was refused by the defendant, no question of formal tender of the amount to be paid arises, and the question to be decided is whether is not whether any money was within the power of the respondent, but whether the appellant therein definitely and unequivocally refused to carry out his part of the contract and intimated that money will be refused if tendered. Push up next para. Learned counsel, by placing reliance on the above judgment, argues that in the circumstances of the case at hand as well, the defendant stroke respondents had categorically returned the money tendered to them, and as such, there is no dearth of readiness and willingness on the part of the plaintiff stroke appellant, and the appellant should not be called upon to prove the same afresh. For sub next para, learned counsel next cites judgment of a learned single judge of the Allahabad High Court reported at AIR 1983 Allahabad 843, where the learned single judge, inter alia, observed that the plaintiff apostrophe's readiness and willingness must be in accordance with the terms of the agreement. Full stop. Next para. In the present case, it is argued that the question of putting in the consideration money would arise only upon vacant and peaceful possession of the premises is handed over to the appellant by the respondents upon eviction of the tenant thereat. Full stop. Next para. Learned counsel next cites a coordinate bench, a division bench judgment of the Bombay High Court in such and such reported at AIR 1989 BOM 170 in support of the self-same proposition. Full stop. Next para. Learned counsel argues that the Supreme Court, in such and such reported at 1973 SCC 140 had also observed that in that case, there was nothing to show that the appellants did not have the funds. First up, in the said case, a sanction was to be obtained by the respondents, that is, the defendants in the said suit, for transfer of the plot from the Rehabilitation Ministry. First up, it was held by the Honorable Supreme Court that in view of the said sanction having not been obtained, the question of readiness and willingness of the plaintiff did not arise. First up, next para. Learned counsel further submits that in the circumstances of the case, there was a negative covenant in clause 18 of the term sheet, which stipulates that the vendors shall not enter into any contract, agreement, MOU with any third party during pendency of the term sheet. Full-stop, learned counsel, comma, by placing reliance on section 42 of the Specific Relief Act 1963, comma, argues that since the negative covenant, that even in the event the positive part of the agreement has not been complied with, comma, there is no bar in the court passing an injunction with regard to the negative covenant. Full stop. Next para, learned senior counsel appearing for the respondents argues that the term sheet relied on by the appellants.
I'm going to take minutes.
Ye-
Can you leave?
Yes. You want to take leave?
Yes.
Yes.
Miss Oja has taken
Appellant
leave.
term sheet relied on by the appellant does not amount to an agreement which is specifically performed at all. Full stop. The said agreement, comma, it is pointed out, comma, is an agreement to enter into a further agreement which cannot be specifically enforceable in law. Full stop. Next para, learned senior counsel places particular reliance on clause 16 of the term sheet, which provides that vendors will enter into an MOU with the purchaser subsequent to the term sheet being executed, and thereafter will execute the deed of conveyance as per terms of such MOU. Full stop. Learned senior counsel relies on uh, the judgment of the Supreme Court in the matter of such and such, reported at 2009 1 SCC 475, where it was laid down that it is a well settled legal proposition that an agreement to enter into an agreement is not enforceable, nor does it confer any right upon the parties. For some next para, learned senior counsel next argues that readiness and willingness is implicit in a suit for specific performance, and at all points of time the readiness and willingness of the plaintiff has to be established. Full stop. It is argued that section 16c mandates such compliance with the said provision. Full stop. In support of such argument, comma, learned senior counsel cites JP Builders and such, reported at 2011 1 SCC 429, where the Supreme Court, comma, inter alia, comma, held that the distinction between double inverted readiness and double inverted willingness is that the former refers to financial capacity and the latter to the conduct of the plaintiff wanting performance. Full stop. Generally, comma, it was held, comma, readiness is backed by willingness. Full stop. Next para, also relying on the other proposition laid down in the said judgment, comma, learned senior counsel points out that the Supreme Court observed that in a suit for specific performance, comma, the plaintiff must allege and prove a continuous readiness and willingness to perform the contract on his part from the date of the contract, comma, the onus of which is on the plaintiff. Full stop. Next para. Lastly, comma, learned senior counsel relies on such and such, reported at 1995 5 SCC 115, where it was laid down that the remedy for specific performance is an equitable remedy and is in the discretion of the court, which discretion requires to be exercised according to settled principles of law and not arbitrarily as adumbrated under section 20 of the Specific Relief Act. Full stop. Next para, the readiness and willingness of the plaintiff to perform his part of the contract, comma, it is argued, comma, is an integral part of such exercise of discretion by the court. Full stop. Next para, under such circumstances, comma, it is argued that the learned trial judge was justified in refusing injunction. Full stop. Next para, before parting with the matter, comma, learned senior counsel points out that as per clause 13 of the agreement, comma, which is relied on by the appellant, comma, the vendors stroke respondents were only to assist the purchaser stroke appellant in a swift and effective termination of the tenant at the property within 6 months from the execution of the term sheet. Full stop. Simultaneously with the execution of the term sheet, comma, the vendors had accordingly issued a termination notice as well to the tenant. Full stop. Next para. However, comma, the appellant neither complied with clause 13 by taking initiative for filing an eviction suit and having the plaint vetted by the respondents, nor was any due diligence compliance on the part of the appellant. Full stop. Next para. Upon a careful consideration of the arguments of parties, no, sorry, learned senior counsel lastly submits that the term sheet is insufficient, is not stamped or registered, and as such cannot be the premise of grant of a degree of specific performance. For sub next para, upon hearing learned counsel for the parties, it transpires that the term sheet in question is the plinth of the submission of both the parties. Full stop. Next para, we are aware of the settled legal proposition that at the ad interim stage, the learned trial judge could not look beyond the plain pleadings and the pleadings in the injunction application and annexures thereto. Full stop. As such, we have to proceed on the premise that the pleadings in the plaint were sacrosanct insofar as the consideration of ad interim prayer of injunction is concerned. Full stop. Next para. On the premise of the plaint case, the term sheet raises an arguable question as to whether the stipulation therein to enter into an MOU prior to execution of the deed of conveyance is an essential feature of the term sheet, or the same is an ancillary condition of the agreement. Full stop. We say so because there are contradictory provisions in the term sheet itself. Full stop. Whereas clause 16 provides that an MOU has to be entered first and thereafter a deed of conveyance executed as per terms thereof. Full stop. At the same time, we cannot gloss over the fact that even as per clause 16, the parties are mandated to execute a deed of conveyance by virtue of the term sheet itself, although via the intermediary of an MOU. Full stop. Next para, that apart, there are certain clauses which directly relate to the deed of conveyance. Full stop. Next para. For example, clause 14 provides that the vendors will pay all the KMC tax and clear all arrears on or before the execution of the conveyance. Full stop. Again, clause 18 provides that the term sheet is valid and binding upon the vendors and purchaser as a contract and will come to an end upon execution of conveyance in favor of the purchaser, thus creating a continuum notionally between the term sheet and the deed of conveyance, without mandatorily introducing any stopover of an MOU in the interregnum. Full stop. Next para. Thus, it is arguable as to whether the term sheet was merely an agreement to enter into an MOU or the agreement itself comprising the essential clauses necessary for entering into a deed of conveyance directly. Full stop. No hiatus is contemplated in some of the clauses between the execution of the term sheet and the deed of conveyance. Full stop. Since such triable and arguable issue has been raised, undoubtedly a prima facie case has been made out to grant injunction, at least at the ad interim stage, in favor of the appellant. Full stop. Next para. The question which arises is whether the appellant is required to show the readiness and willingness at this juncture. Full stop. Next para. The interpretation sought to be lent to clause section 16C is not borne out by the judgment cited by the appellant. Full stop. Next para. The judgments in Maniklal Kormokar, international contractors and international contractors, respectively by the division bench of this court and the Supreme Court, were rendered prior to the coming into force of the Specific Relief Act 1963. Full stop. In none of those judgments, section 16 within bracket small c of the 1963 Act were discussed. Full stop. Also, the context of Maniklal Kormokar was somewhat different, where as a general proposition, it was being considered whether monetary payment was the only method of exhibiting readiness and willingness. Full stop. Next para. such dispute now has been set at rest by several judgments of the Supreme Court, particularly in NP Thirugnanam, এটা হচ্ছে 1995 যেটা সেটা Thirugnanam, where it has been categorically held that specific performance is an equitable remedy as in the discretion of the court, and readiness and willingness has to be proved by the plaintiff at all stages. Full stop. Although we are aware of the fact that by a subsequent amendment of 2018, the 1963 Act has been amended to particularly the previous section 20 thereof, which granted discretion of on the court to grant or not grant a degree of specific performance. However, still then, the settled proposition of law remains that the degree of specific performance, by its very nature, is an equitable remedy and can be granted or not granted at its discretion by the court, subject to equitable conditions being satisfied by the plaintiff. Next para, also, in JP Builders and another supra, the Supreme Court categorically laid at rest any doubt as to readiness and willingness by observing that readiness refers to financial capacity and that the plaintiff must show continuous readiness and willingness to perform the contract on his part from the date of the contract, which onus is on the plaintiff. Full stop. Although by amendment to section 16 within bracket small c, the necessity to aver readiness and willingness in the plaint itself has been omitted, the said provision still provides that the plaintiff has to prove that he has performed and has always been ready and willing to perform the essential terms of the contract. Full stop. The expression double inverted always clearly indicates that at all points of time the plaintiff is required to be ready and willing to perform the part of the contract, his part of the contract. Full stop. Next para, the submission that prior vacant position was to be handed over by the respondents to the appellant is neither here nor there. Full stop. Readiness and willingness has to be proved on the premise that as on the date of filing of the suit for specific performance, the plaintiff is ready to perform his part of the contract if a decree of specific performance is passed in his favor. Full stop. It is not the case of the appellant that the appellant would desist from taking the fruits of the decree if a decree of specific performance is passed today, even without any eviction of the current tenant being affected by the respondents. Full stop. Thus, it is an absurd proposition that the show of readiness and willingness is dependent upon prior eviction by the respondents of the tenant as per the terms of the purported contract. Full stop. Hence, we find that in the event the readiness of the plaintiff is substantiated by deposit of 50% of the total consideration of money of rupees 7 crore 50 lakh, as undertaken previously before this court by the plaintiff, the plaintiff is entitled to an order of injunction, since even the trial court has held that there is a prima facie case in the matter and the pleadings indicate the urgency involved. Pleadings of the injunction application indicate the urgency involved. Full stop. In view of the above, FMA 1499 of 2025 is allowed on contest, thereby setting aside the impugned order bearing order number 2 dated July 16, 2025, passed by the learned civil judge senior division 9th court, in charge at Alipur district South 24 Parganas in title suit number 1054 of 2025, and passing an order and granting an injunction restraining the respondents and their men and agents from selling, transferring, alienating, and or transferring the suit property which is the subject of the agreement in question in favor of third parties in any manner whatsoever till disposal of the temporary injunction application pending in the trial court, subject to the plaintiff stroke appellant depositing
50% of the total consideration of rupees 7 crore 50 lakh in the trial court within a period of 4 weeks, 3 weeks. If you are there, then 2 weeks. Within a fortnight. Within 3 weeks, within 3 weeks from date. Full stop, next para, there shall be an unconditional order of injunction in terms of the above order for a period of 3 weeks. Full stop, in default of such deposit of 50% of the consideration amount, comma, the interim order of ad interim injunction, the ad interim order of injunctions shall stand automatically vacated. Full stop, next para, in the event such deposit is made, comma, the ad interim injunction shall continue till the disposal of the temporary injunction in the court below. Full stop, next para, the defendants stroke respondents shall file their written objection to the temporary injunction application in the court below, comma, if not already filed, comma, within 3 weeks.
The 3 weeks, your lordship is giving them time to deposit. 3 weeks.
3 weeks from date. Full stop, next para. It is expected that the learned trial judge shall dispose of the injunction application itself as expeditiously as possible, comma, preferably within a period of 4 weeks from the date of filing of the written objection by the respondents. It is made clear that the merits of the injunction application and the suit pending in the court below have not been gone into by this court. Can such and such is disposed of in the light of the above observations. Are disposed of, can 1 or can 2?
And the FME. Along with the
FMET has been allowed. That is the first line.
Milord, next item number 6 and 7, Milord. We have filed application on the last day before vacation, Milord. We could not obtain the, Milord, the case number. In the vacation and during vacation, we have obtained.
What do you want now? Quickly. We have that.
Is not 2 weeks time for the service of the response.
Any caveat is there?
No, Milord.
I call করুন তো 6 চট করে
WPLRT, Milord.
6 only 6
6-7.
6-7 board দেখান 6-7 on the prayer of the petitioner the matter is adjourned till November 17 2025.
Great, Milord. 6-7.